May I please, your lordship, with the consent of the other side, I beg to mention item number 28, lordship. In this matter, lordship, we are led by learned senior counsel S. Dr. Lordship. He's out of station. Matter may pass over for 1 week, lordship. May come
Who's there
after.
for the other side?
SP Chaudhary, we
Yeah,
have,
please, my lord. I'm from the other side.
we have
You
taken.
don't have any objection?
No, my lord.
If a request is made to adjourn the matter on behalf of the appellant by learned counsel, so and so. You are for the appellant,
Yes, my lord. I'm for the appeal.
behalf of the respondent. कर देना. The appellant's counsel has no objection. List after 4 weeks.
My lord, there is an interim order that may
Interim order shall continue till next.
oblige, my lord.
All right.
Lords, I'm seeking to mention item 16 due to some personal difficulty, my lords. Your lordships can allow me,
16 is then with the entire bunch.
my lords,
So the
15,
bunch goes is
15 and 16, my lords.
Hmm?
15 and 16 are
15 and 16. All right. 15, 16, 17. 18. All.
Lords.
All right. And counsel for the, you are for the appellant,
yes, my lords.
seeks an adjournment on for personal reasons. List up to 4 weeks.
My lords may give a short date, my lords, and grant me
Not possible
permission.
now, not possible. Otherwise also these are 23 matters.
Lords may grant me permission to appear through VC, my lords.
That you can of course do. List up to 4 weeks.
Grant me
hearing.
permission, my lords, to appear through VC.
Huh? You don't need a permission. We are allowing everyone.
Okay, my lords.
There's no need to, the hearing is being done by the hybrid mode. Don't worry.
Lordship, item number 22, it's a state appeal, my lord.
Hmm.
A batch of writ petition was there, my lord, against a common judgment. We are filing the other appeals, my lord. We need 1 week time, lord.
Council must not submit that more appeals against the impugned order. The order impugned in this appeal are being preferred and would come up for admission. And hence all the matters may be taken up together. List up 2 weeks.
Lordship. Lordship.
Yeah, please, your lordship. Lordship, I beg to mention item 25 of the daily list. Lordship, the arguing counsel is suffering from conjunctivitis. Lordship.
It is stated that the arguing counsel, Mr.
MSD goes, your lordship.
MSD Ghosh is unwell. A request is made to adjourn the matter. List up 4 weeks as well.
Deeply obliged.
Item number 26, my lord. In this case, the virus of the medical admission rules 2023 amendment is under challenge. There's some urgency on their part, but my lord, we are yet to file an affidavit. I pray Lordship may take up on Tuesday. By Monday, we'll file an affidavit on behalf of the department.
Counsel for the
Health department.
Standing counsel at the Health and Family Welfare Department submits that some more time is required to file affidavit on behalf of the department, and thus the short accommodation may be granted. Re-notify on 29th.
Can be a little bit earlier, my lord, because the classes will start from the 1st of September, my lord. Any day in the next week.
25th.
Obliged.
Lordship, my lord, we have filed an IA in a pending writ appeal. So it may kindly be listed on Monday, my lord.
What is the IA about?
IA, my lord, in spite of pendency of this appeal, the learned single judge is continuing the writ petition. So there may be res judicata. It may kindly be,
Pendency of the appeal. All right. It's against an interim order.
yeah, yes, there is interim order, but we want to stop the proceeding because if the parallel proceedings go on, then
Tuesday. It is instead of Tuesday.
on Monday, my lord.
Tuesday. Yes, please.
Daily list for orders, item 20 and 21.
May it please, your lordship.
What is the controversy, sir?
Yes, my lord, what had happened in this case? The respondent's number, my lord, respondent number 1. He filed a writ petition assailing the industry seniority list in the cadre of my lord, enforcement inspector. Now, my lord, the case projected by the writ petitioner before the learned
Enforcement or transport?
Transport Department, my lord. Yes, enforcement inspector in the transport department.
Hmm.
Now, the case projected was
Hmm.
the appellant before your lordships, who was hired in the, my lord, merit list, he was a 3F appointee. Therefore, until and unless his service is regularized, his service cannot be counted. And my lord, admittedly, his name appears at serial number 20 of the merit list,
His means?
the writ petitioner.
Huh.
And learned single judge has held, my lord,
Hmm.
that since my service was, since I was originally holding the 3F appointment,
Hmm.
therefore my seniority cannot be given. He is deemed to be senior.
Your appointment was regularized. When was it
Not
regularized?
regularized, my lord. I was also selected like him. There's nothing called, there's no, under the recruitment rules, there is no provision of regularization.
Hmm.
Now, if a lordship could kindly come to my lord, page number 45.
Of your appeal. 257.
Yes, my lord, 257, yes.
There's a
Page 45.
states, what is, IA is by the state.
IA
IA is
was-
for what purpose?
Well, I think they want vacation of the stay order.
All right.
The whole matter can close, my lord.
The very simple matter. It's subject matter.
What is she saying?
My lord, I am not submitting anything regarding who is eligible for promotion or not. But my lord, I am submitting according to the rules. What the rules says, my lord. Lordship may kindly have a look at transport rules.
Let him argue.
My lord.
What do you want us to close? What do you want us to close? Your IA?
No, whole
You
matter-
made a statement that you lordship may close. Close what?
The entire petition lordship may.
So we are hearing it.
My lord,
All right, you are ready?
my lord.
Okay.
Yes. My lord will come to page 45. This is by the chairman, Public Service Commission to the secretary, Government of Transport Department. 76 candidates were interviewed by the commission with the help of experts.
Page number 45.
45, my lord. Annexure 2 in the memo of appeal, my lord.
Yes.
76 candidates were interviewed by the commission with the help of experts deputed by the government. The following candidates are recommended in order of preference. My lord, serial number 7 is the appellant. If your lordship will kindly come over to the next page, page 46. Serial number 20 is the, my lord, writ
Yes.
petitioner.
The petition.
Respondent number 1 in the
Himanshu
appeal.
Kumar Das.
And that too, he is a reserve category candidate. My lord. Now, my lord, single judge has said that since I was a 3F appointee, therefore my seniority could not be given above. I do not know under which jurisprudence this is permissible.
Okay. Very good.
This is the case, my lord.
Hmm.
Of course, in between, there are certainly intervening facts. Now, my lord, based on this selection, now what had happened?
Hmm.
In 1993, February 1993, my lord, the appellant was appointed as an enforcement inspector under Regulation 3F. I'm not praying for my counting of seniority from that date. I'm praying for counting of my seniority from the date of selection.
Date of selection.
Now, my lord, there was.
The date of
certain-
selection is 22nd January 97.
Yes.
Okay.
Yes, my lord. Now,
So-
there were certain intervening developments, my lord. For alleged involvement in a criminal case, appellant service was terminated on 8/9/97.
Okay.
Yes. Now, my lord, my termination, I assailed in the civil rule at that point of time, my lord, writ petitions were prescribed as civil rule. It was 284 of 98, my lord. An order was passed, which your lordships will get at page 52.
Yes, please.
The operative portion. In the meantime, validity of the select list dated 22/1/97 shall stand extended, and one post of enforcement inspector in the Department of Transport, Government of Assam, shall not be filled up until further order from this court. This was the interim order. Then final order is at page 53, my lord. My lord will kindly come to page number 59. While disposing the, my lord, writ petition, this was the view which was taken by this court.
Page number 56.
My lord will kindly come to page 57, my lord.
Mr. Chaudhary, yes, there's some counsel who is addressing through VC,
I think Mr. Mohanto, my lord.
this very item. All right.
Yes,
He represents the respondent or?
one of the appellant, my lord, in another case.
There are two writ appeals.
Yes, all right.
I'm reading from the first para, my lord.
Hmm.
The petitioner Manoj Kumar Chaudhary, the appellant, was appointed as enforcement inspector for a period of 4 months by order dated 4/2/93 as provided in under regulation 3F of the Assam Public Service Commission, limitation of function regulation 51. While the said period was extended from time to time while the petitioner was so serving, he participated in a selection process pursuant to the advertisement issued by the Assam Public Service Commission. Although the advertisement was for 20 posts, but it was restricted to 14 posts only. And Assam Public Service Commission issued. a
So
select-
let's come to the operative part.
Yes. operative
Ultimately,
part
it has
is
been said that
page
after disposal of the criminal case,
Yes,
the
page-
appropriate action will be taken.
yes, madam. Page 59. The learned counsel for this, second subpara, the learned counsel for the petitioner submits that the fate of the petitioner will depend upon the outcome of the criminal proceeding.
Hmm.
In case the petitioner is found guilty of the criminal act, his fate is sealed and he will not be eligible for any appointment on the basis of the recommendation of the APSC. On the other hand, if the petitioner is not found guilty, his case for appointment have to be considered by the state as per the recommendation. As the
Before that,
select list,
Mr. Chaudhary, before that,
yes,
there is one more intervening fact, which
Yes.
is there at bottom of page number 58.
58, madam. Yes,
The order dated 8/9/97 whereby the service was terminated
yes,
has been revoked by the government-wide notification dated.
yes, yes,
Question here is, was there any order of continuity of service?
yes,
Let us see that order.
yes.
Let's see that.
My lord will kindly take note of 2, 3, a few dates, my lord.
Hmm.
My lord, 4/2/93, the appellant was appointed as.
Forget about 4/2/93 for a moment, because you yourself say
Ah.
that appointment need not be reckoned.
Yes, yes,
Appointment was actually made in 97
yes,
selection,
yes,
right?
Yes.
So 97, then you were terminated in the very same year.
yes.
And then the order of termination was revoked in 2001.
9/9/2001, my lord.
So where is that-
Termination order was revoked.
Where is that order of revocation?
Yes.
What does that indicate?
Am I attention, huh? Page 67, my lord. The governor of Assam is pleased to drop the departmental proceeding drawn up against Manoj Kumar Chaudhary, enforcement inspector White, order dated so and so, exonerating him from the charges. His period of suspension.
So where is the order of termination, please?
Yes. My lord, all these things are given in seriatim in one affidavit, my lord.
Can we have a look at the order,
Yes,
sir?
yes, I'm placing that, my lord. Okay, next what we have there, huh?
Because Mr. Chaudhary, stricto sensu, this order doesn't say that your termination is being revoked. This only talks of your suspension being revoked.
No, no.
But if you have been terminated,
But all these things are given in seriatim, my lord. My lord will kindly have page number 286. 286.
okay. Yes,
This is the suspension order, my lord. First. Then, my lord,
286.
yes,
286 is not the order. Some
suspension order, my lord.
paging mistake, pagination mistakes are there.
Running page 286, my lord. It's order dated 31/3/97.
Not there, sir, not there.
Additional part of the additional evidence.
No, we are on that.
Yes. Kindly see, my lord, Manoj Kumar Chaudhary, and for his working under, so he is hereby placed under suspension with immediate effect. Then my lord will kindly.
Now
come to
come to this, sir.
Ah.
Yes,
Ah.
let's see.
287 is the termination order.
287.
Yes. my lord. The services of Sri Manoj Kumar Chaudhary appointed by as enforcement inspector under regulation 3F.
Terminated with immediate effect.
Yes,
Now come to vocation order.
yes. Now please come to page 288.
Yes,
The department's notification dated so and so regarding
So,
termination of
this
service.
cancellation, Mr. Chaudhary, doesn't give you a continuity of service. There is a break. That is settled law, that if the termination is set aside, unless there is a specific order that the services will be counted for the intervening period.
My lord will kindly read the whole order, my lord.
Yeah, we have read it. After the revocation, the suspension was continued.
No, kindly, yes, that means, my lord.
He was suspended.
Huh.
He was suspended afresh after the termination was revoked.
Yes.
Yes. Now in the next
Now,
order,
next order,
the order period of suspension has been regularized.
yes, page 290.
That would be from 9th February
No, my
2001.
lord, 290.
Yes.
Governor of Assam is pleased to drop departmental proceeding drawn up against Manoj Chaudhary while exonerating him from the charges.
Yes.
His period of suspension also is treated to be for all purposes.
Mr. Chaudhary, the period of suspension started from 9th February only.
No.
Before
period of
that, there was no
suspension started from 31/3.
No, sir, after termination, now what can be the suspension? Once the employee is terminated, what is the meaning of suspension? Tell us.
No, my lord, because the criminal case was going on, that's why.
Chaudhary, termination and suspension, please tell us the difference
I
between.
understand.
Teach us on that.
But my lord, when the,
Learn.
no, my lord, lordship will not take such a technical approach in this matter.
No. There's no
When
question of technical.
No.
There's no question of technical approach. That's a substantive order of termination. There is a difference of day and night between a termination and a suspension.
No, that I understand, my lord.
So if an order of termination is set aside, revoked, cancelled, there has to be a specific indication that the period intervening during which the employee remained under termination
No, my lord,
will
the
be treated as
government's
continued.
intention is very clear. His period of suspension,
Suspension, not the period of termination, sir.
no, my lord,
very
first
clear.
he was suspended, followed by termination.
So once the termination comes around, the suspension is washed off by itself.
And my lord will kindly come to this order
Yes.
at page number 289.
Yes. We've seen
Without
that.
prejudice to the pending departmental proceeding, the suspension order of Manoj Kumar Chaudhary, Enforcement Inspector Nalbari communicated by so-and-so is hereby withdrawn with immediate effect.
Yes.
After his reinstatement, he is posted at the office of the District Transport Officer, Secretariat Borpeta.
Right.
So there is continuity.
What is the date of suspension order, sir? 9th February 2001. Mr. Chaudhary, can a terminated employee remain under suspension? Tell us.
No, my
There
lord.
is a big glitch.
No, my lord. For that, why should I suffer? Government may.
You should have filed a litigation then. You should have come to the court praying that this order should be treated as continuity in service. You never played that.
That is the understanding of the government.
No,
That is why, my lord, I have been given seniority. They have counted my seniority from the date of my selection.
You tell us one judgment you come out with, that period of termination, unless specific order is there, that it will be treated after being set aside, it will be treated as continuity in service. That service break will not come in picture. Give us one.
Lordship will kindly come to page 287 for a moment.
Yes,
my
please.
lord.
Yes, please. Sure.
The services of Manoj Kumar Chaudhary appointed by the order as enforcement inspector
You see, there
and
is a,
placed under Sassan so are withdrawn, are hereby terminated.
Mr.
with
Chaudhary,
immediate
there is a
effect.
flaw in all these orders. Basically, the flaw is they lost sight of the fact that he was later on appointed by a regular selection process. So they are contemplating as if his appointment was only under
My lord,
3F.
if my understanding is not wrong, my lord, what's government understanding was, though it is not very clearly spelled out. Prosecution knows in Nelson Motis's case, Honorable Supreme Court said, my lord, if there are certain technicalities, then my lord, when you have to reinstate him, then he should be deemed to be under suspension until.
Give us that
government takes a
judgment, give us the
final
law,
call.
give us the law that this period of termination, unless there is
No,
a
my lord.
clear explicit direction that it will be treated as period on duty, spent on duty without wages. What about the salary during this period?
No,
Did
I
you
was
get
not-
salary?
I was not paid salary because
So,
I did not
Mrs.
work.
Ms. Salary, Ms. Chaudhary, that's where the issue pinches. That you did not get salary. There was no order of continuity. How this period can be?
One second, salary part to be considered, okay, part of- My lord, that salary part, I'm not very sure, my lord, that will have to take
Yes,
instruction.
if you got a salary for that period,
Hmm.
then of course it's a different matter.
Hmm.
Then of course we can presume
Ah,
that the period was treated on duty.
yes.
But where is that explicit expression in the orders?
No.
Let's come out with the law.
Their lordship is correct, my lord. Technically, there are certain aberrations in the process. But my lord, why should I suffer for that when the intention of the government is
No, it
otherwise?
was never, sir. It was never, the government never said that this period will be treated as period spent on duty.
That's why my seniority has been counted from
So,
the date of
That's
my
why the challenge.
appointment.
That is why the challenge,
No,
that
no,
it is
no.
illegally.
No, learned single judge has not dealt with all these issues.
Maybe,
Learned
maybe.
single judge has dealt with an issue in my humble submission. That's absolutely wrong. Kindly come to the learned single judge's finding, my lord.
But Ms. Chaudhary, once that aspect has come to
No, no, satisfied.
note, then you have to satisfy us
No,
first.
we're satisfied.
Satisfy on that, then only you can proceed.
Let me have that instruction, my lord.
Definitely. During the course of arguments, comma.
My lord, the instruction is got the salary.
No, my lord, that is where, let them put it on affidavit.
Come on, affidavit. Yes,
Let him put it on
We'll-
affidavit. He could not have.
we'll record this in this order. Give an affidavit.
Okay.
Uh,
And my
During-
lord, I'll come up with case laws on the point of.
yes, yes,
Yes,
definitely. That we'll like to be benefited by
Yes,
that.
yes.
During the course of
Salary paisa. Sure.
hearing the arguments, comma,
Ekdam total.
during the course of hearing, comma,
My lord,
This court-
may record that submission that on instruction I have submitted.
better
and
it is
also-
that you
yes.
come out with affidavit. Uh, It is transpired from the documents placed on record,
Technically, they're
that-
right.
the services of the.
My lord,
appellant- Yes, Mr. Manta.
my lord, my appearance may be in respect of 21 number, my lord. Item
All
number
right.
21, my lord.
We'll hear you later. But terminated with effect from 31/3/97. What is the date of order of termination? Where is the order of termination?
8997.
Where is the order of termination?
It is at page 287.
287.
87.
My lord,
Right order dated. Yes, please.
287.
We are passing order first in the appeal of Mr. Chaudhary, sir. Wait for a
my
while.
lord, it is analogous. These facts are accepting, my lord, termination of the Mr. Sodri's line. The other aspect are, my lord, similar because the selection list is same where my name was appeared in serial number 1, my lord. So, my lord, this is a difference between this, my lord.
We understand, Mr. Manta, but we first want a clarification on this aspect.
Yes, yes, my lord. All right.
Were terminated by order dated 8 September 1997. The said order was thereafter
Withdrawn.
cancelled by order dated 9 February 2001. First of
I continue to be.
a perusal, the 9 February 2001, which further directed that the appellant Manoj Kumar Chaudhary would remain under suspension thereafter. Full stop. The order of suspension was then revoked on 22nd March 2001. Full stop. There is a gray area in this matter because the orders referred to above do not indicate that there was any direction to treat the appellant in service during the period he remained out of job because of the order of termination, which was subsequently cancelled on 9 February 2001. Ms. Chaudhary on oral instructions states that his client was paid salary for the intervening period. He prays for and is granted a short opportunity to bring on record the material facts to substantiate this government re-notify on 28th, 28th,
28th, I am
29th,
can it be 30th?
30th. You will be in
My lord,
Itanagar.
I'll be before the Supreme Court on 28th.
My lord, 38, I have a difficulty, my lord. If you lordship can prepone also, I don't mind, my lord, before 28 also.
Before 28th, Mr. Chaudhary will not be possible. But then it goes to 7th or 8th September. That is the
8th September.
8th September. The other appeal also. Sunit Kumar Poda. Mr. Manta, would you like
My
to
lord,
argue independently or you will?
No, my lord, will come along with my lord. Please come together, my lord. The same is case is otherwise same, except my suspension and termination period is not in my case, my lord.
8 September.
Otherwise, the selection is the same.
Yes, yes.
My lord, I'm sorry, my lord. Instead of 8, could it be on 12th, my lord?
12th September.
And deeply obliged.
Master, please.
The government council may also take instruction on this
Yes, yes.
regarding the salary part.
Item number 23.
My friend is under trouble. Well, I seek for a small accommodation added to Monday or Wednesday. Well, the secret. Well, from Monday. Having some bronchial problem.
Okay, okay. Must come out, seek short accommodation on
Wednesday tomorrow.
account of health issues, re-notify.
Wednesday.
He is otherwise very fit. We should not accept his submission.
No, it's a night.
The man who buys cycles for 180 kilometers, pleading, seeking adjournment on the ground of.
That man, my lord, when he drinks cold water, this is what happens.
That's right. That's right. This is a season wherein the cold water should be avoided. Hot drinks are in the order. Yes.
Much obliged.
When do we want?
Monday, Wednesday, whenever it's convenient to your lordship.
Wednesday, 23rd.
Wednesday, lordship. Thank you.
Item number 24.
24 is same, 23 are same. Hmm. ले लो ना कॉल कर लो उसको.
Item 27.
Is for the appellant. Chakravarti.
Chakravarti is there.
All right. Pass. 1 week कर देना. None present for the Union of India. List up to 1 week.
And the date may be given, my lord.
Give it on 7th September. List on 7th.
Can it be 9 September?
9 is probably a Saturday. Then it goes to the week starting from 11th.
11,
Then fix it on 14th September.
14. Obliged.
Call this 29 also. Ms. Saikia, we will need your assistance
Item 29.
for the purpose of just sharing what is wrong with the criminal justice system in the state.
Lordship.
We will let you know what is the problem.
Lordship.
And we need serious efforts to rectify this.
Lordship.
Maybe a few cases may fail, but ultimate objective should be, then fine then. Yes. You ready?
Yes, sir.
Okay.
Yes.
Give out the brief facts. Yes, based on oral dying declaration, right?
Yes, Lordship. Solely based
Okay.
on oral dying declaration.
Hmm.
Lordship, the brief facts of the case is that on 20th August 2013,
Hmm.
an FIR was filed
Hmm.
whereby stated that at around 6:30 PM, while the informer's father, namely Mr. Bimal Basumatari, was coming from Hell Bridge Bazaar by bicycle, suddenly he was attacked on the way middle of the
Hmm.
Dudua gate near the Gongia River by Sri Somna Boro.
Hmm.
According to Bimal Basumatari, Somna was trying to destroy him on the spot only, but somehow Bimal Basumatari was who escaped from the.
Don't read the FIR, Mr. Counsel.
Yes, Lordship.
Just give out the brief facts.
Yes, Lordship. So he.
So the assault was made on 28th August, 27th August
27th August.
at 6:30 PM. Ms. Saikia.
Lordship.
The victim is taken to a hospital allegedly. No treatment is given. He is then taken home. It is said that he makes an oral dying declaration in presence of his son. Next morning, he is taken to the police station in that condition, wherein he has got allegedly 6 to 7 stab wounds. From the police station, he is sent to another hospital at
In Kuch Bihar, Lordship.
Kuch Bihar.
Yes,
In
private
West Bengal.
hospital.
Kuch Bihar, There what treatment is provided, no one knows. He expires, postmortem is conducted, charge sheet is filed. The only evidence is oral dying declaration. The accused absconds, that is one circumstance against your accused. Now, the doctor who conducted postmortem report not examined. The treatment records from Kuch Bihar Hospital or the hospital where the victim was first taken not brought on record. How do you prove the case? If you see the postmortem report, madam, show the postmortem report to learned advocate general. You must be having the photocopy. You just like to share the original one.
Yes, Lord, if I have it now.
No, photocopy won't work, Mr. Saito. For personally speaking, for myself, I have never been comfortable with this paper book business. I always like to see the original records.
Regarding the external injuries, it is in page.
Look at this one.
Original one, nine.
Look at the original. Surgical wounds. Unless the doctor who examined the victim when he was brought to the hospital comes and says that these were the wounds he was suffering, which I repaired by the surgical process. How do you prove that these injuries were received in the manner alleged?
A blatant mistake, Lord.
Even the doctor who conducted postmortem was not examined. And this is happening, ask the learned public prosecutor. This is happening right, left, and center in n number of cases. What do we expect? You are in serious need, an immediate and urgent need of a prosecution department. Because
that process
these-
is already on, Lordship.
These are public prosecutors appointed on the basis of
No,
the
we have
political
found, Lordship,
appointments.
last 1.5 years, we have found, it is very shocking to tell this honorable court, that we found about a large number of public prosecutors, they are not taking any remuneration from the government for 10 years, and they are happily doing the work. We found out in January 2022. And we had,
There is an illustration of that fact in this paper book. Take out DW1 and 2. Show it to learned advocate general. The case is based on oral dying declaration. Two defense witnesses come in the witness box, say that we went to the house of the deceased when he was brought there in injured condition and he was not in a position to speak anything. Learned PP says cross-examination declined. Oral dying declaration is otherwise also a very weak piece of evidence. And now defense comes out with a pertinent plea that he was not in a position to speak. This, of course, otherwise also, if we were to believe the oral dying declaration, you would have to prove by the medical evidence that after receiving these injuries, the victim was in a position to speak. No medical evidence. The IO proves the postmortem report. That's right. Yes, seriously, I'm telling you, if it had been in Rajasthan, many heads have rolled. If this was the negligent state of affairs. So this public prosecutor system, even if you set up a prosecution department, in the sessions cases, you will be appointing public prosecutors who are from the government to government basis, 5 years appointment. You need to train them, sir.
We are going to have a proper cadre of the public prosecutor.
They will be appointed in the grade 1 and grade 2 courts,
Yes.
not in the sessions courts. Sessions court, the appointments will be under the CRPC 24.
Under the CRPC.
Same manner.
That also we are going to have a state amendment. We have
Okay.
started that process also.
So even in the sessions courts, you will have
Yes,
prosecutors from the cadre.
yes,
That will be good.
yes.
That
That
will be-
amendment, we have already started the process.
Okay.
And already the process for appointing 3 persons, Lordship, the prosecution director and 2 additional prosecution director. That advertisement is also out.
So we know where the lacuna is. Lord.
Presently,
The
that,
lies we have come to know.
that process will take time.
It will take time.
For the present, you need to
And
train
we
the
have also-
prosecutors who are there in the sessions courts at least. So this doesn't come around. Not examining the doctor. Now, what do we do? Do we remand the matter or what?
It is a criminal offense, Lordship, on the part of the PP and the IO. It's a criminal offense against them. And we have already taken action against one of the person. A very famous case, Sweta Agarwala's case in Guwahati. One person was given death sentence and one person, and it came to the appeal. My Lord Justice S. Siam was there and it was remanded back for retrial. We have started the process to take action against the IO Lordship. He will be the first person who will be, the government will be going against.
But in this case,
The major flaw,
the problem is, even if we remand, we don't have any material from those two
is
hospitals.
that Lordship, it is not that they do not know the procedure. It is not that he does not know that the IO has to bring the concerned police or doctor. But it
Not
is-
only
when
the
it is
concerned doctor-
deliberate, then it is the
Mr.
problem.
Advocate General, not only the concerned doctor who conducted the postmortem autopsy,
Others also.
but the doctors where, the hospitals where he was taken first.
Lordship, I have no quarrel on that proposition, Lordship.
No,
but
no,
only
we are-
when
we
the
are-
IO
we are
is
not-
deliberately
We
doing
are
it.
not criticizing anything. We want the system to be improved.
System, that is why I'm
One
saying,
case or the other will not matter much.
when the PP is not taking remuneration for 10 years, what does it signify?
That clearly shows what is happening.
What is happening? We have found out all these things.
Why don't you replace them?
The process we have already started.
So that encadrement is not required for this purpose. They are appointments like
That is short-term measures we have already taken, Lordship,
okay.
but long-term, Lordship, because they are accountable and there will be transferable job also.
That
Just
is
like the NIA and the CBI are doing. We are following the same model here.
okay. But in the meantime,
These damage has already been done for last 10, 15 years or maybe more than that.
yeah, that's
What
right.
will happen now in future? That we can rectify.
Yes.
We cannot change the facts here of the case.
No, that's not. We were thinking that is it possible to redeem something by remand?
Exactly.
Because
That is why that Sweta Agarwal, when it was sent back for retrial, then we rectified the mistakes.
But in this case, what can be done? Because you don't have any record from those hospitals where the victim was taken at the initial level. So
The
for remand,
magistrate could have asked for the re-examination, re-investigation, but that stage is
yes,
also gone.
at the stage of filing charge sheet,
Exactly.
if there had been a prosecution department, the investigation could have been
Talwar's case, just like that, Lordship.
Yes.
But here, it is too late in the day.
beyond redemption. That's a problem.
But we have come to know, Lordship. Lordship's monitoring also is helping. Just now I had a long discussion with the DGP. Whatever suggestions the other day Lordship directed, we are doing on that. Regarding all the data from the fingerprints, etc., we are on the process. It is already doing. I will place it on record.
Very well. Just we are showing our concern that
Very seriously, Lordship, and we are doing whatever is based
this
within the shortest
is
possible time.
the prime requirement when you talk of law and order in the state. The investigation has to be on the prime
Yes, Lord.
front.
That
Absolutely.
area, we are a little bit comfortable now, law and order. This area, Lordship, now. we have
Investigation
to-
part, yes, unless you are able to punish the offenders, maybe you are able to keep them behind bars for 6 years, 7 years. But that doesn't serve the purpose
Exactly,
unless there is a punishment commensurate with the offense.
Lordship. The right message should go to the society also.
Absolute. So what is your argument?
Lordship, Lordship has already.
No, we have not said anything. You are amicus curiae or engaged counsel?
No, Lordship.
You are engaged counsel?
Yes, Lordship.
So all right, earn your brief.
Yes, Lordship. Lordship, in this case, the FIR was filed by prosecution witness 1. Prosecution witness 1. And
He was not an eyewitness.
no, he was not an eyewitness.
So can you tell us a flaw in the FIR? A very important flaw is noticeable.
Yes, sir.
What is that flaw?
The victim stated about the whole incident to PW2, prosecution witness 2. And the prosecution witness 2 did not file the FIR, Lordship. In fact, PW1 on the very next day, after 24 hours, he filed the FIR,
No,
which is not a direct.
no. That is not anyone can file the FIR for that matter.
Yes, Lordship.
There is no difficulty. What is the distance between the house of the deceased and the police station?
Lordship, 1 kilometer.
1 kilometer.
1
Yes.
kilometer.
So first flaw is delay in lodging of the FIR.
Delay in lodging the.
Second flaw is omission in the FIR. Omission of what? Does the FIR have any indication that the deceased made a dying declaration?
No, Lordship.
No. So that is the omission which goes to the root of the matter.
Lordship.
Come out with a judgment.
Lordship. I'll
Have
come.
you tried to find out? Did you read any judgment on this point?
Yes, Lordship.
Which judgment? All right.
Lordship,
You didn't even build up an argument that there is an omission.
Lordship, actually, my argument was based on the fact that the dying declaration was directly, Lordship, the dying declaration is an indirect declaration that was made to PW2, Lordship.
So oral dying declaration is very much admissible.
Lordship,
There
it
have
is
been
admissible.
convictions based thereupon.
Lordship, it is admissible,
Then
but to the point that it is truthful and it is unbiased.
yes. So what was the reason that the deceased would falsely implicate you? A dying man doesn't tell lies. That is a cardinal principle.
Yes, Your Lordship.
Right.
But neither the investigation authorities, neither the police, neither any doctor, nobody had recorded any dying declaration.
We are posting it in the next week. Come out with
Lordship.
judgments. Read one judgment, 1975 Supreme Court. Param Kumar versus State.
Lordship.
Probably 1026 is the page number. Next.
Oblige.
And yes, you will have to answer one more thing. When the accused was absconding, why should it not be treated to be a incriminating circumstance against him? 24th लगा दो।
Supplementary list, item 30.
Is that NI Act matter?
Lordship. That without troubling your Lordship on the facts for the present, if I could get the query which fell from your Lordship yesterday was, of course, that under the jurisdiction conferred.
All right, Mr. Manik, let us forget about that. What has happened in your, have the parties settled?
Yes. I told me yes.
It's been settled, my lord.
It's been
Then why do you want to continue with the complaint?
I don't want to, my lord.
So then file an application in that court.
We have filed an application brought on record with regard to the materials on record and the decree of the family court, which is.
That's all right, but have you taken steps to withdraw those complaints?
Yes,
Or
yes,
which-
we have already started, my
There
lord,
are-
and
there
that's
are-
why we got it listed.
Where is
before
the
you.
application? Where is your application?
My husband and the father-in-law are not the complainants before the court below. Two other persons are.
In Punjab, there are,
Absolutely.
the checks were given to somebody else.
Allegedly. My husband and my father-in-law are not the complainants, number one.
Okay.
While in the state of Punjab, these proceedings ensued, we took steps to file applications in this honorable court under Article 226(2). Interim protections were granted, and thereafter 3 interlocutory applications were filed. One by us for amendment of the prayer, because at the time of registration, just like in this honorable court, initially we have a filing number, thereafter we get a court registration number. Similarly, during investigation period, there's a number, and once the notice is issued, there's a different number. So we wanted to incorporate that on record. An application for was filed to that effect, and 2 applications were filed by them, praying for modification of the interim order. All the matters were taken up together, club, or modification of the interim order. There was interim protection granted by this court, of course.
Yes.
Keeping the maintainability open. That aspect is still open. Now, since there was an order on the application for amendment for incorporation that was allowed by this order, without indicating anything as to the fate of the continuation of the interim orders. And since there are 2 lines of schools of thought, my lord, that whether it will continue or not, and this matter.
Mr. Banik, the issue is, had it been a complaint by the husband
my lord,
or the father-in-law,
lordship,
situation would have been different.
True.
Now it's a third person who has filed the complaint.
I would address your lordship on that. Would my lord
Yes.
permit me on that? Now, one thing is maintainability of an application in this honorable court under Article 226(2). And the,
Territorial jurisdiction.
my lord,
Yes.
and the other thing is whether I successfully concluded or not, or it's dismissed on merit. So far as I would address this issue is that the jurisdiction conferred under Article 226 is state-wise. In Guwahati,
Supervisory jurisdiction of the High Court.
the writ jurisdiction would be 226 state-wise. Now,
Not
when-
even the writ jurisdiction, it goes beyond that. Is supervisory jurisdiction, 2 to 7.
227 is there.
Yes.
I'm on 226 and 226 for the moment, so far as
Yes.
the case is concerned. Now, supposedly, Rupan Icon, now supposedly there is a criminal proceeding in any state, except for the state of Assam and the outlying benches below. Then, to challenge the continuations of the proceedings, I have two options to go. Number one, 482 in the appropriate High Court, or 226 in that court, or 227 in that court.
32.
32 in the apex court. I'm only High Court, correct.
Right, that's all.
Now, it's not a question where I want to proceed there or not. But if the law of the land gives and confers a jurisdiction on a different High Court having a territorial jurisdiction beyond and without that jurisdiction, then subject to fulfillment of conditions, I may invoke, now it's may, by an application under Article 262. This is on the theory of cause of action having partly arisen. Now, I'm addressing your lordship to that without taking the matter to the facts. I would be incomplete in my submission without order consult. There's a judgment of this apex court in March. How do you think that? What do you think that? No. This is on this part. My lord may refer to paragraph
Sir, this
14.
is a tax matter, Mr.
No, it's not
Bani.
a tax matter. I'm not on a tax matter at all. I'm not.
This
on
is
a
a
tax-
tax
I
matter,
am-
sir. In a criminal, come
I-
out with
I
a
have the
case.
judgment again on the criminal matter.
All right,
I
give,
am not on that.
come out. of the
Paragraph
criminal
14
case.
for a moment.
Yes.
May I read it?
No,
What-
this judgment doesn't apply. Tax issues.
May I read paragraph 14 for a moment?
Yes.
May I try to impress upon your
Very
lordship?
well.
While dealing with an objection as to lack of territorial jurisdiction to entertain a writ petition on the ground that the cause of action has not arisen within its jurisdiction, a high court essentially has to arrive at a conclusion on the basis of averments made in the petition memo, treating the contents as true as correct. This is the fundamental principle. This is regardless of the fact of tax, of the fact of any other notification issued under any other law. The fundamental principle is by
Should
my
we-
averments.
Should we ignore para 13, sir?
My lord. This is on the facts of the case, so far as online lottery was issued, the issue was concerned, but on the facts of 226(2), my lord, so far as criminal jurisdiction is concerned, the criminal part is concerned, very well, 226 application can be filed. Now, if 226 application cannot be filed, then 226(2) necessarily cannot be filed. Now, since 226 can be filed, only issue is whether in the narration of facts and the pleadings have been on the case of 226(2). The answer was yes, so which the interim
Banik,
protection was
In a
granted.
case of NI Act, what is the concept of territorial jurisdiction? Let us know. Does any law say that where the check was issued, that gives rise to a cause of action? It doesn't. The cause of action arises only after the check is presented. The place of issuance has nothing to do with the
This-
jurisdiction.
I would appreciate your lordship.
Yes.
This is so far as
If you take the finding right now, maybe your challenge in the writ will also be prejudiced.
I understand.
That is your
I
choice.
understand. What I'm submitting, my lord. if
Yes.
Lordship permits, my lord. Lordship is absolutely correct.
Hmm.
That test comes when the proceeding under the NIA is being appreciated by the jurisdictional court. I am on a point when the Honorable High Court takes up the matter, whether the initiation of proceeding is abuse of the court, the process of the
Abuse of process of court, the High Court has jurisdiction only within its territorial jurisdiction.
even.
That is 482, plain and simple.
May I-
482 jurisdiction can't be excised beyond the territorial jurisdiction of the High Court.
Would my lordship permit me to place this? as-
Definitely.
This is Niharika infrastructure on that phone, my lord.
Yes.
And since I do not have a copy, may I read from my cell phone? my lord?
Yes, yes.
Obliged, lordship. Paragraph 15 and 15 first. This talks in the negation of the ultimatum, but does not bar the initiation. 15 paragraph. One five.
Yes.
Hence, in the present case, the High Court committed a grave error in accepting the contention.
You're reading para 15.
1-5.
Yes. Para 15 starts from as observed here and above.
There. Due to paucity of time, we could not get a printout more.
As observed, you're bringing out a citation from live law.
Lordship.
Don't understand.
So we could get an SSC online also, but due to the paucity of time, we could not.
Paucity of time means what?
In substance, it talks about 226 and 482 in the realm of the both can be filed in case of quashing of criminal proceedings. What
There is no dispute, Mr. Banik. 226 can very well be filed. You don't need this judgment. Go to Safan Kumar Goa State of West Bengal. 226 can definitely be filed as a constitution bench judgment.
In that,
but only in a high court having jurisdiction.
In that context, my lord.
Yes.
226(2) jurisdiction of this honorable court would come if I set out my pleadings correct. If I have not set out my pleadings correct, this conferment of jurisdiction is not there, my lord.
All right. Read from your pleadings what part of cause of action arose here. And for that purpose, you will have to satisfy with the NI Act also. In a complaint of NI Act, what is the concept of a cause of action?
My lord,
territorial jurisdiction.
Without going into this for the present, if I may submit one thing, my lord. Since we are in writ appeal on the touchstone of whether or not the interim order is extended or not, and the maintainability part is still kept open, we both don't lose the forum, let the matter go back on that point.
So withdraw your appeal. What prevents you from doing so? Withdraw your appeal, go there and agitate. We are not continuing the stay. We are prima facie satisfied that your proceedings are absolutely without.
I can come again. What I am on is that we do not lose a forum then. On the touch that interim order, which was there,
Mr. Banik,
some observation is not
when your proceedings are fundamentally lacking jurisdiction, why should we grant you interim protection?
Then would my lord be pleased to pose this matter on Monday, on the point whether we go back to the honorable single judge or we finish up the matter here.
Very well. Monday.
21st. 21st, the other matter is also fixed.
Do you have the instructions from those complainants? Just hold on.
My lord.
From
Those
those
been withdrawn, my lord. My lord, will can you see?
withdrawn.
My lord, will can you see the IA that we have filed in, my lord?
Then what is the problem, Mr. Banik?
IA, my lord, we have paid as per the court decree, my lord. Family court's decree also.
No, decree can't be operative on those complaints, Ms. Counsel.
No, my lord, that's been part. Number of cases been filed, all been part of the decree. And my lord will kindly come to the IA that has been preferred, my lord, at page 44.
Yes.
Yes, I have this to confirm that I have received a payment of 6 lakhs from Ashan Sharma. Husband, I have taken the burden to
page 44.
Yes. So and so pending before Amit sir for the amount receivable against bound check number so and so drawn on HDFC. I have received the full amount and there is no outstanding due.
Will be withdrawn.
This
reads will be withdrawn. Has it been withdrawn? Confirm that. Fact.
My lord, my lord, what I am on is very limited. My lord, they approached before this honorable court, preferring this writ appeal on the ground that my lord, that stay order has not been extended. 226(3). And my lord, what is the law with regard to this? Now there was
14 days. If the order is not extended, it lapses.
Mandatory or directory?
Mandatory.
Mandatory, my lord. As per our High Court, Manipur High Court, we follow it. Now, subsequently, there to this honorable court in a division bench matter, my lord, Honorable Justice Koteswar Singh and brother judge was there, say that it is directory, and the matter has been referred to a larger bench. Now, the question before this honorable court is very limited. Now, till pending of this criminal appeal, which law is to be followed? The law prevailing will be followed, and that's been answered by the Supreme Court, my lord, in a matter.
Yes.
I'm facing it before the honorable court. That is, my lord, 2000.
Why don't you make a statement, sir, instead of going into everything, but that the complaints have been withdrawn, then chapter closes.
My lord, the money has been paid.
But have the complaints been withdrawn or not?
One of the petitioner, my lord, here, my lord, this petitioner, my lord, most probably have expired also. This one, my lord, the person concerned, my lord.
Who?
The complainant.
How do we know that? Find out whether the complaints have been withdrawn or not.
Rana Pratap, my lord. I'll find it out, my lord. Let
find out.
21st, my lord. 21st, my lord.
21st.
And that line of thinking was not even the action of this case, my lord, whether interim orders were extended or not. In an application for amendment, which was allowed, they are clubbing this concept. That is not even permissible.
On Monday.
Obliged, lordship.
Item 31.
My lord. So I was engaged in this case. I've gone through the brief, my lord. And my lordship might have read the, read, my lord. I leave you to ask lordship.
So we should decide the matter as per our own wisdom, sir.
Without noting my submission, my lord, what I have submitted.
Yeah, of course, we'll not go. We'll say that you have vehemently argued. Okay.
Provided there was such a point, my lord, to argue.
Order is out.
Lovely.
What is the brief submission?
My lords, he was never regularly appointed, my lords. He was a contractual employee and we had stopped giving work since from April 2021. Because his prayer before the learned single judge was that, we should permit him to be employed contractually going further. my lords.
Right.
There was absolutely we filed an affidavit, my lords. There was a direction in the earlier order, my lords.
Very well. Order is out.
There was a direction in the earlier order, my lords, to place the affidavit, which was not filed with the referee. My lords, I have copies.
Give it to you.
Deeply obliged.
We will be, your board will be over right now. 10 minutes. The board will be over in 10 minutes. Then madam ki pass. 5 minutes order. Name dispose.
Item number 32.
Lord, it's regarding regularization of part-time lecturer of the law college. There are three aspects, Lord. Whether administrative instruction will prevail over statutory provision. And second one, the Bar Council recommendation versus Guwahati University Act's provision. And the third one, the applicability of constitutional bench Uma Devi's judgment.
My lord, sorry, my lord, but I have entered my appearance through my filing no color number today, my lord.
Today.
So
So you want time?
Yes, ma'am. So what happened, man, actually, caveat was filed, man, but subsequent, but
3 months.
3 months already expired due to my defective filing, man.
And counsel, your good name, please.
AK Sharma.
AK Sharma puts in appearance on behalf of the respondent number 1. Respondent number 1. He prays for and is granted short opportunity to complete his instructions. Re-notified. That goes on 13th September.
Most of them.
Top of the list matters. Item number 1 to 4.
Lordship, on the last occasion, Lordship asked me to inquire as to what happened to the petitioner's counsel in appellant's counsel in respect of item number 2. I have been informed that the brief has been taken back by the client's lordship from Mr. A.K. Bhuya.
What to do then?
These are all, my lord, those cases where, my lord, the
Security has been
yes, after acceptance. They
forfeited.
decide-
After acceptance, they
the
reside.
lodge decided.
Weight, overweight.
Yes.
They wanted to carry overladen vehicles
That's right.
on the premise that earlier it was being
Yeah.
permitted.
Yes.
Learned single judge has taken note of the provisions of the Motor Vehicles Act.
That's it.
It was always in the knowledge of the transporters that they can't carry overweight vehicles. So in an illegitimate expectation,
Lordship,
it's an illegitimate expectation.
there's some legitimacy to it, Lordship, because the FCI itself was allowing us to load more than.
Maybe,
50
so an
metric-
illegal act should be allowed to be continued perpetually.
No, it may not. be.
FCI may be allowing you to do so, but the inspectors on the road, they will not allow you to do so.
Lordship.
So illegal transportation, they can't be permitted to do
Since the counsel for
indefinite.
the appellant of the retail.
We'll dismiss it for want of prosecution. That is the problem of the party.
Can it be taken up some other day, Lordship? Senior counsel, Mr. K. Chaudhary will appear in the matter, Lordship. He was here
24th,
Lordship.
hardly anything in these appeals.
Item number 5.
Yes.
But sir, here in this case, the staff selection commission has filed this appeal, Lordship.
Hmm?
Staff selection commission has.
Probir Ghosh.
Yes.
After Probir Ghosh, what remains, Mr.
My lord,
That is,
if I'm permitted, my lord, I'll show that Prosecution does not govern this case. Prosecution actually.
Sure, you should.
distinguishes my case, and
Yes.
actually I should be allowed, my lord.
Very well.
Appeal has to go.
Very
May-
well.
may I show? Lordship will-
All right. then. Argue.
Lordship, me or. Let's place my argument in my written synopsis. Lordship, in this case, the respondent was a candidate in the recruitment of general duty in Central Armed Forces, Lordship. As a rifleman in Assam, in the document published on 3/12/2001, 11. The respondent was a unreserved category candidate belonging to non-border district of Assam. The respondent was declared medically unfit initially in detailed medical examination, whereupon he went on appeal and declared medically fit in review medical board. Respondent obtained 44 marks in the written examination. The respondent did not exercise preference option for forcing his application form. That was blank. As for the scheme for the recruitment, candidate who had not exercised any option were not considered for inclusion in the select list. Such candidates were considered for allocation in reserve list 2 based on merit and subject to availability of vacancies in their respective category. For the state of Assam, there were unfilled vacancies under general districts of unreserved category under CRPF and ITBP. Since the respondent obtained only 44 marks, he was not selected in RL2.
What is RL2?
That was a reserve list to
Reserve
was
list two.
formulated for filling up those vacancies
Which are
where people had not
Made any option, given any option.
given any option and where
So in that list, he did not secure the cutoff or required number of marks.
Yes.
what had
First
happened is, my
and
lord,
second lordship,
Hmm.
he didn't fill up his option.
Hmm.
So for which armed forces he want to be selected.
All right. He didn't fill even the,
Yes.
which force he wanted to join.
Yes, sir.
Okay.
Lordship, then he preferred writ petition that was allowed.
Hmm.
The appellant respondent contested the prayer by filing affidavit and contended that the candidate who had not exercised any option were not considered for inclusion in select list, and as such candidate were considered for allocation in reserve to list 2 based on merit and subject to availability of vacancies in their respective categories. The last selected
We'll read this, Ms. Kell. Don't narrate the
lordship in our affidavit, this is our specific ground. Lordship.
that he secured only 44 marks.
Yes.
And so he did not make it into reserve list.
Yes. Lord.
That
Thereafter,
is not countered by the respondent.
Yes, sir. Thereafter,
Okay.
thereafter, Lordship, we filed writ appeal, and the writ appeal was kept pending, awaiting the decision of the Honorable Supreme Court. Lordship, Lordship may come to paragraph 7, Lordship, page 3,
Of Probir Ghosh,
Lordship,
page 2.
page 3, paragraph 7.
Of what?
Pravir Ghosh.
Probir Ghosh, we have got this Supreme Today
Yes, Lordship.
copy. So page 2,
Lordship, the
para 7.
Original judgment also available in the record. Also.
So page para 7 you want us to read?
Yes, annexed to the recruitment
Ah.
notification.
Yes.
Contain instruction for filling up application. Column 16 under paragraph 4.0 of the said instruction dealt with preference for post. The column 16 under paragraph 4.0 of the annexed 2 to the recruitment notification dated 3/12/2011 read as follows. Candidates should correctly indicate preference for post under different forces. Forces. Options once exercised will be final and no change will be allowed under any circumstances. Now, let's say may come to paragraph 10, Lords. Paragraph 10, after completion of the process of selection.
Come to paragraph 15.
Paragraph 15, yes, sir. in this appeal, civil appeal number 24, only two issues arising for consideration. Are that whether the rejection of the OBC candidate for few candidates on the ground that they were not in prescribed format, and consequently categories of those candidates.
So we are not concerned with this, part two, second part.
Whether the candidate who have indicated preference to a particular service can be kept out of consideration for appointment to other services despite these candidates having secured more marks than the selected candidate in those services. Now let's see paragraph 31.
Para
31.
31.
As we have indicated in paragraph 18 above, two questions arises for consideration in CA number 24. Only one question arises for consideration in the other civil appeals arising out of judgment of the Delhi High Court. The questions that come to the appeal arising out of the judgment of the Guwahati High Court and the appeals arising out of Delhi High Court is whether candidate who have indicated preference for particular service can be kept out of consideration for appointment to other services, despite such candidate having secured more marks than the selected candidate in those other services. In column 16, under paragraph 4.0 of annexure 2, which is the brochure containing instructions for filling up the applications, candidates were called upon to carefully indicate preference for the post under different forces. It is also made clear that the options once exercised will final and no chance will be allowed thereafter. Paragraph 34. The reference for BSF was to be indicated by the alphabet A for the preference to CISF, CRPL, SSB, IBB, and Assam are to be indicated respectively by alphabets B, C, D, E, and F. The respondent are candidates who have clearly indicated their reference to one service only. Some other candidates have indicated preference to multiple services, as these were no prohibition under recruitment notification to do so. What the Staff Selection Commission did was to confine the consideration of the candidate who indicated preference only to one service to the service only. Candidates who have indicated multiple preference were considered for all those services, and depending upon the cutoff marks, they were allotted to one of the.
You would be banking on Vindhyachal Kumar Singh,
Not
saying that I've left it blank.
Yes.
So fit me in any of the services, wherever I come as per the merit.
In fact, at paragraph 41, my lord, it is discussed.
No, no.
In Vindhyachal Kumar Singh, the Allahabad High Court was concerned with the case where the candidate left a common.
Before that, come to paragraph 36.
No, 36. Paragraph 30. Ultimately, the respondent in these appeals indicated preference only to one service. They
Yes.
did not secure more than equal to the cutoff mark for the service in the category to which they belong. It is true that the candidate who secured lesser mark than these respondents have been selected in other services, but it was because of the expression of their
Openness to any service. So he doesn't mark any preference. Wherever he fits it as per his merit. That is what the.
But he was less in merit in general category.
In general category, he didn't secure marks.
He secured 44 marks.
Yes.
Lordship, we have indicated
From
in
that
our-
aspect, right? So he doesn't get into any service on the basis of his marks.
But in his option, we kept it blank. Lordship.
So he says wherever as per my marks, I can be fitted in.
The last
Do that.
to be accommodated in CRPF and IDP as per the orders of the learned single judge is 43. I have secured 44. One post was kept reserved for me in the initiation of the repetition. There, that is where I was required to be adjusted. Para 41 Vindhyachal is
Yes, Mr.
clearly
Chair.
discussed.
Lordship, page 33 of memo of appeal. Lordship, part of our affidavit.
Page 33.
Lordship, last paragraph.
Oh.
Page 33, last paragraph. The criteria for selection of candidates found fit in review medical examination was the same as applicable for candidates found fit in detailed medical examination. Candidates were considered for inclusion in select list strictly on the basis of merit cum option, subject to availability of vacancies in state and UT concerned, reservation for border districts and Naxal military affected district and otherwise and category wise reservation. After declaration of selection And reserve.
Was
list.
it a general, Mr. Mazumdar?
My lord.
Come to page 32, para 2. It's a general action they have taken. Those who have not exercised any option
Yes.
were not considered for inclusion.
Now, that is what was considered in Vindhyachal. And in Vindhyachal, it was held that not considering them for anything is itself wrong. They should
Whether
have been-
Vindhyachal was challenged any further?
It was not challenged.
It is paragraph.
Vindhyachal has been appointed. Even
Paragraph
if
41
I just make one submission, my lord.
Para 41 of?
of
Yes.
that Pravir Ghosh.
Yeah, yes,
Every
Mr.
process
Ghosh.
is different.
Paragraph 41.
Hmm.
Vindhyachal Kumar Singh Supra. The Allahabad High Court has concerned with case where the candidate left the column relating to
Yes.
claim.
Yes.
Therefore, the High Court.
So same as the respondent.
Lordship make. Therefore, the High Court held that the absence of any condition or instruction to the effect that if any column in the application form is left blank, the application form would be rejected and the approach adopted by the staff selection was not correct. Therefore, the said case is also not no par with the case in hand.
Yes, so
As a matter of-
Vindhyachal has been distinguished in Prabir Ghosh
Yes,
on facts, and Vindhyachal's facts are exactly identical to the respondent. You can't dispute, and what he states is Vindhyachal has been appointed.
Not only Vindhyachal, but all other cases where options were left blank and this particular judgment was followed. Those people have been appointed. They are now fighting for seniority and salary. This was the first case to be disposed of. Ghazi Rahman. Only he stays back. Lordship will kindly consider 2011, they make a statement in this court that the similar subject matter is pending in the
Supreme Court.
Supreme Court. It is not a similar subject matter, my lord. The Supreme Court has now clarified.
Uh-huh.
Kept pending till today. Contempt kept hanging. He has not got his service for the last 12 years. He is hanging, my lord.
Lordship, this appeal was kept pending, awaiting the judgment of Pravir Ghosh.
On a wrong statement, sir.
Wrong statement.
Prabir Ghosh is an entirely different set of facts. Supreme Court itself says in the judgment, Prabir Ghosh travels on the fact that a particular preference was marked. That is MBBS Murthy's judgment. The law is settled that you will be treated as per your preference. You can't claim merit over preference.
Yes, that is there, Lordship. But
So
here
he has kept it open. Appoint him wherever he fits in. Vindhyachal is the same situation. There was no such indication in our advertisement that non-fulfilling of the preference would invalidate the application form.
In fact, in Vindhyachal, it has been held that this the marking of ABCD, what they have done in the reserve list should have been done prior to the reserve list so that meritorious candidates are not left out. That is
Yes.
the
What do you say,
rationale
sir?
of Vindhyachal.
How do you distinguish him from Vindhyachal?
But if it is not the case, it was also considered.
Hmm?
The Vindhyachal case was also considered by the Honorable Supreme Court.
It has been distinguished on facts. It has not been overruled, that ratio.
Lordship, paragraph 42.
Yes.
As an-
MBBS Murthy, that was a case of filling in preferences. The
Yes.
person who did not fill in the appropriate preference in the ICS examination.
Then they not allotted IPS.
Yes,
What is not accepted that he approached the court, but court rejected his claim.
that was based on a wrong preference. Wrong preference given, and then the candidate claimed, appoint me as per merit. That was the discussion.
Lordship, then the paragraph 5 of that judgment has been quoted here. Paragraph 43.
Mr. Kale, that is a case wherein preference was marked, but the candidate could not get in because that service was filled up before. There's entirely different consideration in that judgment. You have to show that the case of the respondent is distinguishable from Vindhyachal Kumar Singh. Same selection process.
Yes, that is there, Lordship.
So then you can't escape. Prabir Ghosh is distinguishable. You have to give him the benefits, notional benefits from 2011. Do you have the judgment in Vindhyachal Ghosh, the original judgment? Let's see.
Consider paragraph 47 also.
Yes. Read.
Defending the judgment of the High Court, it is contended by the learned counsel for the respondent that so long as the status of the respondent is not disputed by the selection commission, it is not open to them to.
That is regarding the certificate of OBC.
That is not.
That is not a controversy here.
Here there are two questions. One that on.
So OBC certificate is not the issue in this appeal.
No, indeed, that is not the issue.
So then why you are reading para 47? What is the use?
Lordship, may I have paragraph 11 of Vindhyachal, paragraph 11. Respondents' case is that the candidates who did not fill up the preference column, they could not have been considered in the selection based on merit come option. The mere fact that the petitioner securing marks lesser than the petitioner
Scale.
is selected, that is one.
No escape. Vidyaksha Singh.
Here another lordship, my submission will be, because this is the armed forces lordship.
Huh?
And the case is of 2014
11.
lordship.
So what?
So regarding.
It's your illegal action
His lordship that was pending before this honorable court lordship.
On a wrong submission.
on a wrong submission, apparently now. No way out.
What they want to do perhaps is now they put me through a medical test and reject me in the medical. My lord, I am working in the rat mines in Meghalaya as of
Lordship,
today.
Whether it can be.
Working in.
Making those my lord, mining in coal mining, my lord, the ones which have now been allowed. He's entering those mines to pick up coals now. When he had a job in 2011. Today they will go for a medical test and say that you have.
That you will have to clear. There is no
Medical
escape.
test I'll clear.
If
That is
he's
not a
not
problem.
fit lordship, how he can be.
So he will clear the medical test, then only he will get in. If he doesn't clear, that is his problem. Otherwise, your appeal can't survive in view of this judgment. Now, Probir Ghosh itself distinguishes Vindhyachal. All right, order reserved.
I'm obliged, my lord.
Give a brief note, Mr. Mazumdar.
I'll do that.
Mayor, please, your lordship.
Yes.
Lordship, in item number 1 to 4, lordship had fixed it on 24/8. Can it be 25/8, lordship? I've informed the other side, lordship.
25.
All right, lordship.
Item number 6.
May I please, Your Honor? It was against your lordship concurrent finding of the your lordship tribunal as well as the honorable single judge.
What is the
My
scope of interference?
scope, your lordship, the award, your lordship, if your lordship goes through your lordship, will find your lordship. That my claim was rejected
Come
on
to
the,
para 27
of the award, your lordship.
of the impugned order, SB order.
Twenty-seven. In the instances, it is seen that the workmen did not prove a single document as regards the foundation of the case that they were appointed by the management by issuing appointment letters, even accepting the plea that such appointment letters are recalled. It is failed to understand what prevented the workman to produce at least one such appointment letter issued by ID cards, maybe for many other reasons, and cannot be conclusive evidence of the petitioners being under direct employment of the management. No documents in original were produced before the learned. Your lordship, we have your lordship exhibited some certificates, your lordship, against each of the employee, your lordship, some certificates that they are MR workers, your lordship. So that we have exhibited and they have not denied that, your lordship, number one. Number two, ultimately, your lordship, in a case of this nature, when they take the plea that it is under contract labor, your lordship, the learned court below, your lordship, more particularly your lordship in tribunal, your lordship, ought to have gone see whether it is the same or your lordship way or not, your lordship. That is, it is a camouflage or not, your lordship. That is the issue that need to be answered by the learned industrial tribunal, your lordship. But that issue has not gone into your lordship.
You were required to at least prove the basic facts,
Lordship.
which you failed to do. And what was the tribunal to do that?
Your lordship will kindly see, your lordship, that we are employed, your lordship, under their establishment, your lordship, that is not in dispute. The dispute is.
No. They said that they were laborers supplied by the contractors.
Yes, your lordship.
That is what their case is.
That the moment they said that, your lordship, the tribunal ought to have, your lordship, looked into the issue, your lordship, whether it is a camouflage or not, your lordship. That's what your lordship apex code
You
also.
counter that. Did you
Lord-
counter that submission of theirs? In evidence, what did you say? Let's see your evidence then.
Lordship.
Where is your statement?
I have annexed our evidences, your lordship.
Page.
Lordship.
Annexed here or exhibited before the trial?
Exhibited before the trial court, and we have annexed here also, your lordship.
Well, let's see your statement. One of the statements, let us see.
Lordship. Your lordship, page 98, your lordship. That is the, it starts from your lordship, page 86, your lordship. That is the evidences on affidavit, your lordship, of the workman.
86.
86 onwards, your lordship. That I was appointed in the Bongaigaon Thermal Power Stations in the year 1987 and worked there.
Management's witness, you must have cross-examined.
Lordship, MWs I have crossed.
Let us see that cross-examination. Where is it?
I am coming to that also, your lordship. That your lordship will get at 150, your lordship. 50 is the management witness number 2.
150?
150, that is the MW2.
Let's see.
And 131 is MW1, your lordship. It is a fact that 18 numbers of workmen or contract laborers. Exhibit A is an agreement for so and so. In para 2 of the it has been mentioned that APGCL and GOA are willing to transfer the NTPC, willing to take over existing infrastructure of power generation station. In para 18 of the 80, it has been mentioned that the agreement has come to an operation to be effective all purposes and intents from the date of the signing agreement and transfer. Same. I am working under APGCL. ASCB has not been wholly dissolved. Ultimate control of 3 organizations, namely APGCL, APDCL.
So not even a suggestion, sir, that this was a wheel, that they were contract laborers. You are rather establishing their cause in cross-examination.
Lordship, since they have taken their plea, your lordship, ultimately.
In cross-examination, you were supposed to give them the suggestion. They were not contract laborers, they were directly employed.
Lordship.
Whether you have given that suggestion. Read, please. This is the document which shows that it was a direct engagement.
Unskilled laborers has no specific work. For skilled laborers, technical qualifications required. All 18 workmen were unskilled laborers. Their work were supervised by our. This is the, your lordship, the most important factor while determining, your lordship, whether under the principal and their works were supervised.
Yes,
by our
obviously.
office.
So you were working in an establishment
Lordship.
which deals with power generation.
Lordship.
Supervision had to be there.
CPF contribution of the workers were deducted
By the contractor.
And your lordship will kindly see, your lordship, they have brought in PW3 to PW8. Who are the, your lordship, contractors? If your lordship go through what they have said, your lordship for a moment.
First come to the management witness, sir. Have you given any suggestion?
That these are management witnesses also.
So we are asking you, Mr. Votakur, whether there is any suggestion to the management witness that
that's
it was a case of direct engagement, not engagement through contractor.
When they, your lordship, when they have admitted it, your lordship.
What?
That is your lordship. They have, your lordship, that question specifically not put to them.
So then that is your basic case, that it is a case of direct engagement, direct employment, not through contractor.
Lordship.
So you don't put that case to the management.
But your lordship, the way they have projected their case to the contractors, your lordship, kindly go through their management witness number 3 to 8, your lordship.
Yes, read.
MW3, your lordship. He is a cultivator. They are saying that they are the contractors, your lordship, although they have not exhibited any, your lordship, the certificate, your lordship, for contract labor as required under section 9, your lordship. That has not been done. From 1997 to 2002, I was doing the work of a labor supply contractor. I had labor license, supply license. As per the requirement of BTPS, I supplied laborers. I was issued work orders for supply of labor BTPS Salakati for period ranging from 1 month to 3 months. I had supplied 2 numbers of laborers, namely Nipen Bormon and Ramesh Nath. I submitted bills before the BTPS authorities for payment of wages to the laborers. On payment of such bill, I disbursed the wages to laborers. The laborers used to tighten nuts and bolts of the machineries installed there, and sometimes used to replace such nuts and bolts. The works of the laborers were supervised by the engineer. Sometimes I used to be present. The BTPS authority used to ask the laborers to do work sincerely. I am not aware of the fact whether such laborers are provided in a residential quarters or not. In the year 2002, BTPS authority intimated us that no further supply would be required. Then Nipen Burman and Ramesh Nath were earlier supplied by Abdul Salam. I do not know at what point of time they were supplied. Their wages are given by the BTPS authority. Their works were also supervised by the BTPS. So I was not connected to the works of Nipen Burman and Ramesh Nath. I do not know the nature of the works done by the laborers inside the factory. I have not submitted my license or any other document in this case. I have also not submitted order of the BTPS by which I was asked to supply labor. Then next, your lordship. 12 years ago, I have supplied laborers to BTP. I have no license for supplying laborers. I was issued with work orders for supply of laborers, BTPS. I have supplied laborers, namely Simbu Burman. I am not aware of the nature of the work performed by Simbu Burman inside the power station. Bills were raised by us and according to.
There were earlier two references by the unions which were decided against you.
No,
So res judicata also.
lordship, that issue has already been settled by the honorable single judge of this honorable court. When the preliminary issue is decided against us and award was passed, we put that to challenge your lordship and honorable court. This honorable court, your lordship, remanded the matter,
Okay.
setting aside that preliminary issue, your lordship. I do not remember when I supplied Simbu.
You could have summoned the documents from the PF department regarding deductions. What prevented you from doing so?
Lordship, that your lordship, we could have your lordship, even otherwise, your lordship. I admit that your lordship, there are, so far as cross-examination is concerned, that.
There is no
But the-
document, Mr. Gordon.
But the your
Nothing at
lordship
all.
will kindly see this, the management, your lordship, by bringing in these witnesses, PW3 to PW8, has themselves, your lordship, demolished their case. Maybe your lordship will kindly say some of the contractors are saying, we have not even supplied. They are witness saying, your lordship, that
All
we have
right,
not supplied.
maybe.
When they say to your lordship that they are not supplying, and your lordship, there are apparent contradiction between what they are saying.
Reference has been instituted at your behest. You will have to prove your case. They are all along coming out with a theory that it was a contract labor. So you will have to prove that no, we were not contract laborers. You come out with the case, our employment documents were taken back. How that is possible?
Now, moment your lordship, they take the plea that it is we are the contract laborers, your lordship, then it is automatically, it is the responsibility of the honorable, the learned industrial tribunal that they looked into to see whether it is a,
What
to
law do you
lift
cite
the
in-
veil, your lordship.
What law do you cite in support of this?
Lordship will kindly see that your lordship, that is the one constitution bench judgment, your lordship. Steel Authority of India and others versus National Union Water Front Workers and others, 2001 7 SCC. We don't have the right to be regularized, your lordship, that we admit, your lordship. But our case was not, your lordship, for regularization. Our case was dismissed, your lordship, on the ground that, your lordship, referring to a judgment of Uma Devi, your lordship. Uma Devi is completely in a different context, your lordship. It is in the context of regularization of service of the, your lordship, illegally appointed, your lordship, or irregularly appointed, your lordship, employees, your lordship. And only referring to that particular judgment, our case has been, your lordship, claim has been denied, your lordship, saying that our appointment itself is, your lordship, not as per rule, your lordship. That was the case, your lordship. Now, only one aspect, your lordship, one paragraph first, your lordship, I want to show you here, your lordship, para 125, sub para 5. Page number 211, 2001 7 episode.
Yes.
Para 125, sub para 5, your lordship. On issuance of prohibition notification under section 10(1) of the Clara Act prohibiting employment of contract labor or otherwise, your lordship will kindly see, your lordship, even if no such notification is there as claimed by them. In an industrial dispute brought before it by any contract labor in regard to condition of service, the industrial adjudicator will have to consider the question whether the contractor has been interposed either on the ground of having undertaken to produce any given result for the establishment or for supply of contract labor for work of the establishment under a genuine contract, or is a mere reuse camouflage to evade compliance with various beneficial legislation so as to deprive the workers of the benefit they are under, Your Lordship. Now, this issue ought to have been gone into by the industrial adjudicator, Your Lordship, to see whether it is, Your Lordship, reuse or camouflage or a genuine contract, Your Lordship. Now, they are, Your Lordship, they have not produced any documents, Your Lordship, where under the law, Your Lordship, a contractor is required to be registered and obtain a license, Your Lordship. And they themselves will have to be registered, Your Lordship, with the authorities for going ahead with the contract labor, Your Lordship, the employers, Your Lordship. None of those things are, Your Lordship, produced before the
This
land.
deals with the order of prohibition being in existence. In those circumstances, the Honorable Supreme Court laid down this proposition.
Lordship will kindly see the first line on issuance of prohibition notification.
So where
under
is the
section-
notification in the present case?
That is what, Your Lordship, Clara Act prohibiting employment of contract labor or otherwise. This word is important, Your Lordship, or otherwise, even in absence of that, Your Lordship. Because, Your Lordship, for that, they will require the, Your Lordship, registration under the Act, Your Lordship, for going
That
ahead with
depends if
this.
there was a prohibition notification, sir. You never came out with the case that you were employed through the contract labor. You are not on that premise. You are saying that you were directly appointed.
But the moment they take that plea, Your Lordship, that I am, Your Lordship, appointed under contract labor, Your Lordship. They took that plea, Your Lordship. Their case could have been, Your Lordship, that, Your Lordship, no, they are not directly appointed, Your Lordship.
All right.
That is one judgment, Your Lordship, I am relying on, Your Lordship.
Okay, yes.
It has, Your Lordship, clearly said that that aspect of the matter has not gone into by the learned industrial tribunal, and also, Your Lordship, the Honorable Single Judge also does not look into that matter, Your Lordship,
Very
that
well.
aspect of the matter. 125, Your Lordship. And in fact, Your Lordship, and another judgment, Your Lordship, which I am relying on, Your Lordship, that is 1978 4 SEC 257, Your Lordship.
That is on the principle.
How to look into employer and employee's relationship in contract labor dispute, Your Lordship. Para 2, Your Lordship. This has been referred to, Your Lordship, in the Constitution bench judgment also, Your Lordship. It is not in dispute that 29 workmen, Para 2, Your Lordship, workmen were denied employment, which led to reference. It is not in dispute that the work done by the workmen was integral part of the industry concerned. The raw material were supplied by the management. Here also, Your Lordship, these issues, Your Lordship, these are the works we have undertaken, Your Lordship, for the benefit service of the employer, Your Lordship. In material was supplied by the management, that the factory premises belong to the management, that the equipment used also belong to the management, and that the finished product was taken by the management for its own trade. The workmen were broadly under the control of the management, and broadly, Your Lordship will kindly note that were broadly under the control of the management, and defective articles were directed to be rectified by the management. The concatenation of circumstances is conclusive of the question. Nevertheless, this issue is being raised time and again, so we proceed to pass a speaking order. Then para 5, Your Lordship. The true test may with brevity be indicated once again, where a worker or a group of worker laborer to produce a goods and services. These goods or services are for business of another, that other is in fact the employer. He has economic control over the worker's subsistence, skills, and continued employment. If he, for any reason, chokes off, the worker is virtually laid off. The presence of intermediate contractors with whom alone the workers have immediate or direct relationship ex contractual is of no consequence when, on lifting of the veil or looking at the conspectus of factors governing employment, we discern the naked truth, though wrapped in different perfect paper arrangement, that the real employer is the management, not immediate contractor. My right devices of half-hidden of fold after fold of legal form, depending upon the degree of concealment needed, the type of industry, the local conditions, and the like may be resorted to when labor legislations cast welfare obligations on the real employer based on Article 38, 39, 42, 43, 43 of the Constitution. The court must be astute to avoid the mischief and achieve the purpose of the law and not be misled by the maya of legal appearances, Your Lordship. Now, these aspects, Your Lordship, have never been gone into by the industrial adjudicator, Your Lordship.
Okay, very well.
And third case, Your Lordship, I am relying on is 1999 6 SC 439, Your Lordship.
Yes.
I'm coming to the paragraph. Para 27, Your Lordship.
Would have given the list in advance, Mr. Botapur.
I have, you don't. I should have, I'm extremely sorry for that.
Yes, all right.
Para 27, at this stage, it is necessary to note another argument of Mr. Andrujania that in view of the fact that there is no abolition of contract labor in the canteen of the appellant's establishment, it is open to management to manage its canteens through a contractor, Your Lordship. This is the same, Your Lordship, the argument advanced here. Hence, he contends that by virtue of the contract entered into by the management with the contractor, the
Page
respondent.
number 96, 6 S's, you know.
No, Your Lordship,
99
99 6 SS, Your Lordship.
That is the problem. You didn't give the list. 99 6. Yes, read.
Lordship. At this stage, it is necessary to note another argument of Mr. Andrujania that in view of the fact that there is no abolition of contract labor in the canteen of the appellant's establishment, it is open to management to manage its canteen through a contractor. Hence, he contends that by virtue of the contract entered into by the management with the contractor, the respondent workman cannot be treated as the employee of the management. The argument would have had some substance if in the reality the management had engaged a contractor who was wholly independent of the management. But we have come to the conclusion on the facts that the contractor in the present case is engaged only for the purpose of record, and for all purposes the workmen in this case are in fact workmen of the management. In the background of this finding, the last argument of Mr. Andrujania should also fail. Now, Your Lordship, that it is not the case that only in case of Your Lordship, there being a notification only, Your Lordship, this principle will be applicable, Your Lordship. Even in absence of that, Your Lordship, if Your Lordship, the honorable courts find that yes, they are substantially employed by the principal employer, Your Lordship, then also, Your Lordship, their cases will have to be considered in terms of that, Your Lordship. And finally, another judgment, Your Lordship, that is 2003 6 SCC 528. Para 10 and 11, Your Lordship.
What is your prayer, Mr. Botakur?
Lordship, for reinstatement, Your Lordship.
Reinstatement in what capacity?
Lordship, that there's workers, Your Lordship, that they say that we are master role workers, Your Lordship. So in that capacity, we prayed for our reinstatement, Your Lordship. But ultimately, Your Lordship, that issue has not been gone into by the, since the tribunal, Your Lordship. My prayer at this stage will be Lordship.
for a remand.
Lordship, that is your lordship, to look into that particular aspect of the matter, and your lordship, if after that they find that yes, there is no case at all, your lordship, of contract labor, your lordship, then your lordship, we will be out, your lordship. But without going into the merit of that particular matter, your lordship, by applying a ratio, your lordship, which is not at all applicable in our case, your lordship, when our claim is dismissed, your lordship,
Okay.
we are aggrieved by that, your lordship.
Yes. Okay. Yes.
Well, the entire case of the employee, well, before the reference court is
Before
what-
that, your
workers-
lordship, we have prepared your lordship written submission, your lordship, I will hand it.
First.
over.
Yes.
But their case before the.
Evidence
court of
that
page-
they were employed through contractor.
No,
Then,
no, their case is from that page 59.
no, they said that they were directly employed.
Directly employed.
Their employment cards were taken back and they were given some identity ID cards.
No.
What do you say about the affidavit, the certificates which they filed? Certificate issued by your own officer?
Certificates.
Is it the observation of the single judge that no document was exhibited is wrong, palpably
No,
wrong?
no, certificates, if lordship kindly see the certificate.
Yes.
Certificate doesn't say under what circumstances they were appointed.
They don't want regularization, even if they are muster all workers,
No, no.
want to
no,
continue on that same
under
status.
These certificates, under what circumstances these were issued and nothing is there, my lord.
You were
it is
there in
a-
evidence, sir.
No, it is a,
Did you controvert it?
well, kindly see, my lord, what is their case? Well, kindly see 119. What in cross-examination, this is the cross-examination of the petitioner number 1, 119.
Yes,
What he said.
they are laborers, Mr. Nath. What do you expect from
They
them?
were laborers, but they were represented by the council before the court.
Yes, read 118 first.
118.
Yes.
Yes,
He is
118.
the executive engineer who issues certificate.
But
You never denied this
This certificate says that he worked for some time, but this is certified that.
till date,
so and
10
so,
years,
as-
1986
as-
to 1996.
Yes, as skilled laborers,
So-
as master worker, under what circumstances they were worked.
That you should have shown.
No,
That was but those documents were with you.
Malad, I'll take your lordship to management witness number 1 and 2.
Ah, yes,
Malad,
come.
Before
Sure.
that,
Sure.
kindly see, Malad, 119,
Yes.
119, in his cross-examination, what he has said.
Hmm.
However, it is not a fact that I was engaged in Bongaigaon power station for labor contractor Santosh Bosumatari.
Yes.
I was appointed by executive engineer Dipesh Chakraborty.
Hmm.
I
And
have,
they have given the certificates
no.
issued by the
No,
executive
no, that
engineer.
certificate has no relation with his appointment. Kindly see, I had not appeared in interview or written test.
Yes,
No
all right. So
appointment, no
Mr.
appointment
Nath,
letter has been issued
they
to me.
just want their restoration as muster all workers. That's it. They are not asking for regularization.
Well, it is his own statement that no appointment letter had been issued to me. And I used to receive my salary by signing on revenue, but no pay slip was issued to me. I have
Yes,
not exhibited any document.
that
along
is
with
what
my
labor
evidence.
exploitation is, sir.
No.
That is what is labor
Kindly see,
exploitation.
Malad, under what circumstances, Malad, the management witness number 1, it is at page 120.
Page,
120 it starts.
yes, 128.
Logic.
Yes,
So these circumstances we have narrated, kindly come to para 4.
yes.
In the BTPS, there were 664 regular employees of ACB in the rank of official and staff, both technical, non-technical.
Reading at page number 128,
122.
122,
It starts at
affidavit.
120. This is the evidence on affidavit of the MW1.
Yes.
Para 4, I'm reading from para 4.
Hmm.
Logic. In the BTPS, there were 664 regular employees of ACB in the rank of officers and staff, both
So you
technical
should
and
have
non.
produced the contract. Why didn't you produce the contract under which they were engaged?
Malad, in fact, it is their case, page 59, if lordship Malad, for a moment comes to their written statement, para 59 it starts, kindly see para 6. They said it is the issue before the reference court. Malad, what now they have submitted, this was not it was there. Kindly see, Malad, the management authority had initially engaged the workman for a period of 1 year. They failed to show.
Why were you supervising them? The labor contractor should have supervised
No,
the employees.
Malad, in the boiler section, inside the factory,
Ultimately.
Why didn't
ultimately
you
they are
produce, why
supervised
didn't
by
you
the-
produce your provident fund statements? That would have made the things clear.
Well, CPF.
All right, then we'll read your labor contractors you have examined. Let us see. Let us see them. That's the best evidence. Come to that. CW2, MW2, MW3.
MW
3 to 8.
two is our.
We have page number.
154.
Let us see that.
154. But Lordship may also allow me to read the other management.
We lead everything,
Yes,
sir.
yes. Yes.
Don't
Well,
worry.
Management is number 3. But he
Come to,
said
yes, MW3.
MW3, 154. Well, from 1997 to 2001, I.
Come to cross-examination, Mr. Nath.
But he said.
Your case is blown there.
No, specifically, he has said.
Come to cross-examination, Mr.
Nitin
Nath.
Borman and Ramesh Nath were earlier supplied by Abdul Salam.
Next line.
I do not know at what point of time they were supplied. Malad, in 2014, he was cross-examined. And this was after.
Their wages were paid by BTPS authority.
Yes, sir.
So.
But their.
If you are paying the wages directly, gentlemen.
No, we never paid directly. Malad.
That is what the statement is. Your witness. That is why the cross-examination becomes
I was
important.
not connected with the works of Nitin Borman and Ramesh Nath. I do not know the nature of the work done by the worker there because they are unskilled workers. Malad, they supplied and ultimately supervision has to be there from the person's.
Payment of salary.
The salary slip was not there. In fact, in their 119 and all the cross-examination.
Not the entire record was with the authorities. Laborers can't be expected to carry their own records.
But
The entire records with the authority.
least-
Why do we disbelieve the certificates, please? Tell us.
Well, at least the appointment orders.
Why do we disbelieve the certificate issued by your executive
Well,
engineer?
the certificate.
Have you denied in your statement?
Certificate.
What have you said about these certificates?
Certificates, Malad, in fact, Malad, the certificates. Kindly see, Malad.
What have you said about these certificates in your evidence?
Now, as regard the certificates, Malad, they have not said.
Then why do we disbelieve those? Finding that no documents were exhibited. That is incorrect. That is a substantive document
No, certificate.
showing engagement.
The issues, kindly see the issues, Malad, kindly see at page 172 the award.
Wages paid by BTPS, MW4, then
Whether.
MW5 denies. I never supplied anything. So your own witness doesn't support you.
But kindly,
Yes.
kindly come to page 172. This is the issue before the reference court.
Yes.
Whether Supervisor Sunil Bosumatari, Khorgeshwar Nursery, so and so are legally entitled to reinstatement in their service in BTPS. Because they claim that we were appointed by the authority.
Yes.
We were illegally terminated.
Yes, that's right.
And what relief they are entitled as per law.
Yes. So they say
Over their method of.
reinstatement in the capacity of muster all laborers.
No.
That's what they're asking.
No, but they failed to prove that they were appointed.
That is your argument, Mr. Nath. We don't find any merit in your argument.
Lordship may,
Absolutely no.
Lordship may kindly see, Lordship may kindly come, let me allow to read the paragraph 4. Paragraph 4 onwards.
Yes.
Two, three paragraphs under what circumstances they were terminated. But I was reading paragraph 4, that in BTPS there were 664 regular employees of ASAB in the rank of officers and staff, which includes 563 numbers of grade 2 and grade 4 regular employees of ASAB contract laborers, numbering about 602 at present have been.
You could have presented one contract with the contractor for supply of labor. Why didn't you produce that?
But apart from the regular employees, I'm just indicating that apart from the regular employees, there were contract laborers and in fact the contract laborers paragraph 5. Let me read.
Statement, Mr. Nath, is totally false. If you read paragraph 4, you'll find out why. So we didn't need anyone. You already excess staff here. Then why did you engage 664 labor?
No.
Read. Bottom 2 lines, paragraph 4.
Yes, I'm reading. However, since generation of power in BTPS has been stopped since March 2002 due to operational problems as stated above,
there is inadequate work available even for the 664 regular employees of ACB at BTPS. Therefore, engagement of any other worker on contract basis is not economically and commercially viable. And accordingly, a decision was taken by the ACB to stop further engagement of contract laborers beyond the terms of the existing contract.
So why didn't you prove the agreement, sir, with the contractors? What prevented you from doing so? They showed their appointment letters issued.
No. For appointment letter, they have not shown, my lord.
What is that certificate then?
The certificate has no connection with the appointment. When the certificate
The
date.
executive engineer says they are employed with the BTPS. That's a prima facie evidence.
No, my lord, in my respectful submission, my lord, this certificate.
Why shouldn't we draw adverse inference on account of you not filing the agreements with the contractors on record? It's a case of labor, Mr. Nath. You have to be more sensitive. You can't treat it as any other case where the burden of proof is there on a stringent note. It's a case of labor.
Lordship may kindly see, my lord, the certificate has not indicated who has appointed whom. It
Engaged with the
says that they
BTPS.
were there. In fact,
BTPS.
my lord, it is their case that they were appointed from 86 to 95 or 98, whatever period.
Yes.
They worked there. We have also said that, yes, they worked there, but they were not appointed by.
Why didn't you file a single agreement with the labor contractor on records?
Well, kindly see the management witness number 2. So many documents have been executed.
Oh, is that so? Let's see.
Yes, yes.
Which document? Let us see.
Management witness number 2 at 133.
Yes.
Well, paragraph 2, he said that the 18 workmen in question were engaged as laborers for independent contractors and were never in the role of the erstwhile ACB.
So there must have been an agreement, Mr. Nath. There must have been an agreement with the contractor.
Yes. Kindly see the 135. We have exhibit D is the opposite supply number so and so dated 31/11/97. And exhibit E is the bill dated 1/7/97 raised by the said contractor AG Khan for supply. Exhibit F is the payment voucher signed by the contractor. But this we have given. Paragraph 3 I am reading. The contractor AG Khan has engaged Sri Purno Nath, Sri Horisaran Roy, Umesh Kolita, Dhruvo Kumar Nath as contract laborers. The said contractor, namely AG Khan, was issued with supply order number so and so dated 31/11/1997, issued by the then executive engineer, fuel handling maintenance division, BTPS ASCB Salakati, by dint of which the said contractor was requested to supply 13 numbers of unskilled laborers. Accordingly, the said contractor has supplied the required number of laborers and had raised bills for payment to be made.
No cross-examination on this aspect.
But these are given. One more aspect, Your Lordship, I just want to point out, Your Lordship. Your Lordship will kindly come to page 139, Your Lordship.
Yes. Ultimately, we are in writ appeal, Mr. Motakur.
Lordship, I know.
What sort of appreciation of facts is permissible now?
Not gone into, but just point out Your Lordship will kindly see para 8, Your Lordship. The another contractor, Amar Burman, was issued with memo number so and so of laborers by deed and executive engineer so and so. Accordingly, the said contractor has raised bill for wages to be paid to the contract laborers.
Completely exhaustive list has been given.
No, Your Lordship will kindly come to his evidence, Your Lordship, page 158. What is this Amar Burman, Your Lordship, their contractor, Your Lordship, he raised bill, Your Lordship.
Yes.
Now his statement, Your Lordship, will
His
kindly.
statement was recorded when? In 2014. Bills were raised in when? In which year? 2001.
2001.
So 14 years down the line, a man.
What he has said, Your Lordship, he said, I was issued with worker a supply of laborers for periods ranging. from
All
one
right.
month to
Arguments are judgment.
But I never supply laborers to the BTPS, Your Lordship.
14 years makes a hell of a lot.
Your Lordship, that's what Your Lordship his statement is.
Okay.
Apparently contradictory, Your Lordship. I leave it to Your Lordship.
Judgment reserved. Both of you can give brief submissions, written submissions.
Your Lordship, I am handing it over, right?
Yes.
I'll submit. Your Lordship, 150 is the cost of MW2. Nothing has been. Management witness number 2 has
Give
been
a brief note.
Lordship.
Yes.
Problem. Deeply obliged, Your Lordship.
Item number 7.
It is.
Yes. Have you corrected the pagination? Have you corrected the pagination, sir? Okay, start.
The issue in this case, whether this appellant within a specific period of time has collected the target. That was the only issue, my lord. Page 59 may be seen, my lord, the appointment letter.
Yes.
Here, my lord, the column number 2 may be conditioned. You will be on probation for a period of 1 year, which may be extended for further period. So this amount he has to collect that appointment letter page 60. You shall procure a minimum premium of rupees 7.5 lakhs during the probationary period from at least 50 clients with minimum premium so and so from each such clients, or alternatively from 25 clients with minimum period of so and so. This is in the village area. Now, Lordship, he could not collect this amount, so the authority has extended the time for another 1 year.
Yes.
Extended period. Extended period. Yes, page number 270. Yes, 72, madam. This is very important.
Yes.
We are pleased to inform you that the competent authority has agreed to extend the probationary period of Sri Mukul Bushra for a period of 1 year with effect from 24/12/2000. That means from 24/12/2001, which means 23/12/2001. During the probationary period, Sri Bushra will be required to fulfill the following: to procure a minimum premium of rupees 7.5 lakhs, so and so and so. Now the last sentence may be seen, my lord. All other terms and conditions mentioned in the appointment letter dated 23/12/99 remain same. So as per this extension period, my lord, he has collected the premium. Then he was confirmed. After confirmation, my lord, that now Annexure C1 is the most important letter issued by them at page 70.
Yes. Page 70.
70, my lord.
Yes.
Since there is something mistake in this typing letter, the Honorable High Court has allowed me to file a readable copy. That is 118, my lord. Lordship, page 118, my lord. 118, my lord.
118 is a copy of some order passed on 29th May.
High Court, my lord, or decision bench.
Yes.
The court proceedings have been conducted through video conferencing.
Oh, where is, all right, sir, the order we have read.
Yes, my
What
lord,
have you
this order
filed in
is
pursuance thereof?
29/5/2020. As per this order, Lordship, we have annexed the readable copy at page 119.
Yes.
My lord, just for a minute, kindly see, my lord. This has reference to our memo number 5898, advising the premium target for the period of 1/4/98 to 31/3/99 for divisional officers for the purpose of appointment of development officer in grade 2 on probation from any date from 1/4/98 to 31/3/99 in placement of development officer grade 1. Now, Lordship, you can see it has been decided that for appointment of development officers grade 2 on probation from 1/4/99 to 31/3/2000 for premium target to be completed by 12 months. Probationary period shall be as under.
Yes.
Now, my case will be covered by column number, Lordship, column number what, 3. Other center means, my lord, village area. So within extended period, he has collected the premium, and now last column may be seen, my lord. Last column. Development officer, now 3, column number 3. Other centers means village area. Rupees 9.75 lakhs he must collect for the purpose of, Lordship kindly, grade 1. Development officers grade 2 are to be placed in grade 1 on the basis of their performance for 2 consecutive years, including the probation period. My lord, other terms on place for the for placement of grade 1 remain unaltered. So this is unaltered. They cannot alter it. They have issued the interim order by altering this one by giving retrospective effect. That is the case. They demanded that you must collect rupees 10.8 lakh. That I have challenged. My lord, this interim order. Page number. No, page number is annexed, page 67. This is the order they have given retrospective effect, but without cancelling the earlier order. Lordship condition, last column. For placement in grade 1, the premium target to be completed during the 1/4/2000 to 31/3/2001 will be as under. Rupees, column number 3, my lord. Other center means village area, 10.25 lakhs. This is not applicable because first they have committed a mistake for the my lord, the period should be from financial period started from 1/4/2000 to 31/3/2001. Then no, 1/4/2000 to 1/31/3/2001 is not applicable because page 70, my lord, is very much clear. Financial period year will be, my lord, page 72. Page 72, my lord. Financial year will be, my lord, within the extended period. That is from 24/2000 to 23/12/2001. To collect rupees 7.5 lakh first. Then he has to collect the rupees 9.75 lakh. He collected above 10 lakhs at that time. Now, at this age, at the retirement now, he has collected rupees 1.50 lakhs. Now, Lordship will kindly see, my lord. This has been under challenge. Now, Lordship, during the tendency of this case of the writ appeal, the appellant, my lords, has come to know that his case was considered by a scrutiny committee. A scrutiny committee considered, and I have with the approval of the order from the High Court, I have, my lord, filed that affidavit. At page page 155. I'm making very short submission, my lord. Page 155. This is, your lordship will kindly see additional affidavit. The Honorable High Court, my lord, allowed me to file this affidavit by order at page 118. It has appeared 118. The High Court, while the Honorable High Court ordered me, allowed me, I have filed this, and lordship at page, I have annexed this one, and annexure. I'll read this. That while this appeal was, paragraph 2, that while this appeal was pending before the Honorable High Court, the deponent has come to know from a reliable source that the competent committee constituted by the respondent insurance company has examined the records of the deponent as regards the premium target of development officer, confirmation grade 2 and placement in grade 1, and accordingly, the deponent has approached the respondent office on 8/1/21 and somehow collected the copy of the same on 8/1/21. Now, lordship will kindly see page 160. My lord, they have suppressed it in the before the learned single that also. My lord, this is a committee that has made the assessment of the performance of this appellant, my lord. Kindly see, my lord. Date of appointment, page 160. Date of appointment of as development officer 23/12/99. Date of joining in the cadre 24/12/99. Date of confirmation as development officers get to, my lord, 24/12/21. After 2 years, because 1 year was extended, and that 1 year was extended, but it was omitted by the honorable single judge. My lord, terms of appointment as per appointment letter dated 23/12/99 to join office before 21/2000. Probation period of 1 year, which may be further extended. Scale during the period, probation period, rupees so and so, along with permissible allowances. Requirements to be fulfilled now, my lord. Minimum premium rupees 7.5 lakh to be procured during probationary period. Out of the minimum period, 20% from priority classes, so and so. Next, requirement for recruitment assistant in training guide and motivated agent. Other works related to premium collection, cohort, mood issuance, preparation of policy schedule, etc. Confirmation in the service shall not be automatic.
This is not the report of a committee, sir. This is just a note.
Yes, my lord, committee, my lord, kindly see. Yes, page 161.
This is just a note. Read the heading.
Yes, my lord. Now, the note.
Saikya, please read the heading.
My lord.
At page 160. Note to committee. It's not the committee's report.
No, my lord, this is the recommendation. Kindly, my lord, see, just a while. Page 162.
Only the administration officer signs it, no one else.
No, my lord, on the basis of the above, since the employee has fulfilled all the targets, page 162.
It's the opinion of the administrative officer, sir. The committee has not signed it.
My lord, just said.
They've given an affidavit denying this document.
They did not say that this was cancelled.
They said
And
this
none
was
of
never
them-
approved.
My lord, that is, they are silent. Now,
They say this was never approved.
approval, they did not say. Now, my lord, this, they did not say this was cancelled.
Okay,
And
very
none of these signatories have filed an affidavit.
Very well.
One, that's.
They never signed. No one other than your administration officer signed it. No one else has signed it. It bears only one signature.
My lord, that will lordship just for the ends of justice, that I have collected the premium and the officer concerned herself has recommended, has applied the method.
Come to page 167, please.
Anyway, lordship will.
Come to page 167.
And my lord. Yes, my lord.
Para 3.
My lord. Yes, my lord, this is clear affidavit.
Read from top.
This note they have denied, but this note was not rejected. They did not. Now, lordship, I will come to other aspect. This is lordship, I have drawn the attention of your lordship. Now, I will come to one another aspect very important. Now, my lord, page 78 may be seen, my lord.
Yes, please.
70, their own letter, officer's letter at 78. Lordship, kindly see. We are enclosing here which copy of the letter dated so and so, which is self-explanatory. Accordingly, you are requested to inform the concerned government officer regarding the decision of the competent authority. Then, lordship, kindly see page 80. This is a letter prayer to the branch manager by the appellant. Then at page 82, my lord. Page 82, very important letter, my lord. Mayor for special consideration for fixation of grade 2 to grade 1. This letter is issued by them with the branch manager.
So recommendation by the branch manager, is it binding on the authorities?
No, my lord, my prayer will be there that the officers have been, where he is working, were satisfied officials have recommended that he has collected the target within time. Now, whether within time, when I have collected, whether they can go by.
Yeah, that is
They
why
they cannot.
we asked you to read
My lord.
the para 3 of their affidavit, please.
No, my lord,
Page
will-
167.
my lord, I will try to satisfy your lordship. Then you will lordship, page 84. Another letter. Then lordship, page number given.
Yes.
Next page. Page 86. This is another letter. Then my lord, page, page 90 may be condition. For a while, my lord. It is written by the senior, this is service officer, Guwahati. Prayer for fixation of in gate 1. On the above reference, we forward herewith an application so and so, considering the business performance shown by Vosha, we recommend for fitment of his service as grade 1. Prayer for fixation grade 1 Mukul Vishwa may be recommended to GRO considering good business volume introduced by Vosha, which should be encouraged, hence put up for recommendation. Then my lord will kindly see. Lordship will kindly see. Now, Lordship, whether by the interim order, they can give a written certificate. That, my lord, I have brought the judgment because I have rendered service and now on the part of retirement. And your lordship will kindly see this judgment. 1998, my lord, SCC.
Yes.
My lord, kindly see, my lord, the important paragraph is paragraph, my lord, 8. Para 8, my lord. In this appeals, the main contention which has been raised by the agri as well junior clerks is that the vacancies which had arisen prior to 1995, amendment of the rules could only be filed as per the rules of 1978. Therefore, the High Court could not have directed the vacancies which had arisen prior to 1995 to be filled up according to 1995 rules. It was secondly submitted that the number of vacancies which existed being 171, and if the minimum or standard which was required to be attained by the persons taking examinations was 50%, as was alleged to have been stated in the counter affidavit filed in the High Court, and 171 candidates were available, then the number of posts which should have been filled was 171. And the shortfall in filling up the vacancies should be made good. Mr. Singh, on the other hand, submitted that as the clients have been working as assistant accounts ever since 4190, and large number of them retired, only 140 or so remain in service, and who are likely to retire in the future, it will be very unjust that they who were previously working as senior clerks were senior to the other applicants. Now, paragraph 9 is very important, my lord. When the statutory rules had been framed in 1978, the vacancies had to be filled only according to said rules. The rule 19 of 1995 have been held to be prospective by the High Court, and in our opinion, these were the correct conclusions. This being so, the question which arises in whether the vacancies which has arisen earlier than 1995 can be filled up as per the 1995 rules. Our attention has been drawn by Mr. Mayor as to the decisions of the in the case of anti-Davin 30 versus Karnataka Public Service Commission. In that case, after referring to the earlier decisions in the case of so and so, it was held by this court that the vacancies which had occurred prior to amendment of the rules would be governed by the old rules. Now, I will lordship paragraph 10. We are unable to agree with Mr. Singh that by virtue of their length of service while holding current charge as assistant accountants, his clients should be regularized in the said post, merely because the same posts have been upgraded from senior clerks to assistant accountants. it would not be mean that persons who were given the RN duty charts would be regularized without the selection. My lord, then last line, the rules of the para 1978 prescribe the mode in which promotion can be made. This mode has to be followed before the appointments could be made. If no statutory rules had existed, it may have been possible, though we express no option on it, that the existing incumbents have been regularized. Where, however, statutory rules exist, the appointments and promotions have to be made in accordance with statutory rules, especially where it has been shown to us that the rules gave the power to the appointing authority of releasing the state rules. In the absence of any such power of relaxation, the appointment of assistant accountant could only be made by requiring the conditions to take the examinations, which was the method of prescribed by 1978 rules. So the Honorable Apex Court held that you cannot give the retrospective effect. So this is, my lord, another judgment I will take your lordship.
Yes, please.
Yeah. This is my lord, 1993 SCC, page 157, anti-Devin country and others versus Karnataka Public Service Commission. Here, my lord, paragraph 10, 11, 13, and 14.
Yes, please.
My lord, paragraph 10. The state government interpretations in para 11 of its order, July 9, 1970 was incorrect and wrong. He failed to appreciate that in instant case, reservations had already been made and notified under the adjournment published on May 18, 1975. Therefore, the conditions precedent contemplated in para 11 were fully satisfied. In this view, the selection made by the commission by following the reservations and the mode of selection as prescribed under the provisions of the government order dated September 6, 1969 were deemed to have been made validly in accordance with the provisions on para 11 of the government order. It is relevant to point out that the government orders dated September 6, 1969 and July 9, 1975 both had been issued by the government in exercise of its statutory power under Rule 10 of 1975 rules, making provisions for reservation and prescribing mode of selection. The government order issued in excess of statutory powers acquires statutory force. Therefore, the provisions contained in the aforesaid government orders, including the provisions of para 11 of the government order that is July 1975, also acquired statutory character. So para 11 superseded earlier government orders, but it expressly accept the pending selection, which the reservations were already made and advances have already been issued. In para 11, being statutory in nature was binding on the government, and government had no authority to direct the commission. Means of administrative order to revise the select list in accordance with the amended mode of selection as prescribed under the government's order dated July 1975. In your opinion, this state government was bound to give full effect to the provisions of para 11 of the government order dated July 9, 1975, and therefore directions contained in this order April 1976 were illegal. Now in the para 11 also, the Honorable Apex Court held that subsequent amendment is not binding. Now your lordship will see. I will read para 14 only. Para 14. In the instant case, para 11 of the government order dated July 9, 1975 made the government's intention clear that the revised directions which were contained in that government order would not apply to the selections in respect of which have already been issued. Therefore, the mode of selection as contained in Annexure 2 to the government order dated July 9, 1970 was not applicable to the selection for filling up people posts of tahsildars pending to the Public Service Commission. We therefore of the opinion that the select list, including the additional list as prepared by the commission and published March 1976 was legal and valid, and state government wrongly refused to approve the same.
Yes.
And my lord, mine now, next, I will place another. Yeah, we have to do it, no? Okay, do that, Chairman. Madam, here another case before Honorable Supreme Court. My lord, Chief Justice Harma, Justice M.M. Unshi, Justice S.P. Agarwal, Justice A.S.
Is
Anand.
it not sufficient to say that it is a judgment of the
My lord, yes.
Constitution bench?
My lord, yes, my lord.
That
now
would suffice,
this
sir.
is- Lordship kindly see, my lord,
Yes.
my lord, the paragraph 24 may be similar. Paragraph 24. please.
Yes, please.
My lord, in many of these decisions, the expression vested rights or accrued rights have been used while striking down the impugned provisions which had been given respective operation first to have an adverse effect in the matter of promotion, seniority, substantive appointment of the employees. The said expressions have been used in the context of right of flowing under the relevant rule, which was to be altered with effect from an anterior date and thereby taking away the benefits available under the rule in force at that time. It has been held that such an amendment having retrospective operation which has the effect of taking away a benefit already available to the employee under the existing rule is arbitrary, discriminatory, and violative of the rights guaranteed under Article 14 and 16 of the Constitution. We are unable to hold that these decisions are not in consonance with such and such decision. So, my lord, here also the respondent has given a retrospective effect. My right, which I have collected the target within time, within the extended period of time, 9.75 lakh, and more than that I collected in the rural area where there is no bridge in the various rivers. I cycle by going bicycle. I collected the amount, and my lord, they did not give that importance and they remain silent. Now, Lordship, kindly see this in the and my submissions in this affidavit, they did not deny. My lord, this Nasim Banu case will apply. They did not deny that I have collected the money within time and I have done my best in the rural areas and the period extended. That extended period was not counted, my lord, by the Honorable Single Judge. That one year was extended. And then within that, the Lordship kindly another, my lord, that while they have issued their another letter, my lord, just a minute. Malika Handa. On page 70, which I have given a readable copy at page one, page number 150, page number one, page number.
Yes.
That I have given a readable copy as per order of High Court.
Yes.
My lord.
That you already read. Sir.
That my lord, terms and conditions in the last sentence, other terms and condition for grade one
Will remain same.
shall remain unchanged.
That you already read, sir.
Yes, my lord.
Yes.
This they did not
Very
cancel it. Now annexure B also, my lord, they did not cancel it. Now the annexure E that I have challenged, including directing to collect more money, that I have challenged.
Yes, yes. Very well.
My lord, my lord.
Okay.
Now another judgment is here that an employee working through his career should be given at least minimum once minimum promotion. So this is just this is 1983, my lord, volume 3 SCC 254. There, my lord, the seniority and promotion. Panel for promotion, delay in preparing resulting in deprivation of chances of promotion, panel not prepared within the time stipulated in rules and instead done up after amendment of the rules for promotion, amendment dispensing with the original provision of for consideration of LD along with EDA for promotion. Consequently, promotion chances of the eligible LD adversely affected and they were superseded by their seniors in the panel prepared according to the amendment held. Vacancies in the promotional post occurring prior to the amendment have to be filled up in accordance with the unamended rules. And the panel prepared for filling these vacancies under the amended rules set aside fresh panels under these old rules directed to be prepared. Now, my lord, the advancement to question of a man appointed not only for his grade but for his future advancement also. This judgment I have brought on the head. The Chairman related. Yeah. Yeah. Put it there. You think it?
Chairman is there.
The judgment I have brought, I have missed it that advancement of career of a employee is, oh yes, ma'am, I have got it. Worksheet. This is my lord, year 1989, Supreme Court, my lord. Here, my lord, case is Council of Scientific Industrial Research under appellants versus KGS and another. Here, lordship, my lord, Terra.
Yes.
Can you see paragraph? Where it could be. 8, my lord. Right. It seems to us that the submission of counsel for the appellant is not unjustified. Apparently, the bylaws governs only by the promotions of junior scientific and technical staff grade 2 who are engaged in this scientific work. One who is engaged in the scientific work is alone entitled to the benefit of the bylaw. It is necessary qualification for being considered for accelerated promotion. A person who is not engaged in the scientific work therefore stands excluded from the bylaw. In other words, it has no application to the staff who are doing admissive work under the categories of jobs respondent one falls under the admissive category and therefore stands excluded from bylaw. Then that then is the scope of bylaw 71B2, but this does not mean that we should interfere with the relief granted to the respondent one. By pointing out that the error that crept into the decisions of the tribunal, we need to take to its logical end. We should defeat justice. Respondent one is not a layman. He is highly qualified engineer. Although joined service with a diploma in engineering, he later passed Bachelor of Engineering and also acquired MTech degree and one more diploma. He was, however, left without opportunity of promotion for about 20 years. This is indeed a short commentary on the appellants, para 9, madam. Commentary on the appellants management. It is often said, and indeed, a duty and of organization, public or private, does not hire a hand, but engages an or employee as a whole man. The person is required by an organization, not just for a job, but for a whole career. One must therefore be given an opportunity of advancement, opportunity to advance. This is the oldest and most important feature of the free enterprise system. The opportunity for advancement is the requirement for progress of any organization. It is an initiative for personal development as well. Every management must provide realistic opportunities for promoting employees to move upward. The organization that fails to develop a satisfactory procedure for promotion is bound to pay a severe penalty in terms of admissive cost, misallocation of personnel, low morale, and ineffectual performance among both non-management employees and their supervisors. There cannot be any modern management, much less any career planning manpower of management development, which is not related to system. The appellant appears to have overlooked this basic requirement of management so far. Respondent number was considered to demand. So, my lord, the court held that the appointment and promotion, either at public or private, the promotion, at least one promotion is carefully given. Now, here they have stated that I did not take the chance while I was converted to administrative. But I have filed the affidavit that what they wanted to convert me, that was a demoted post. That was a clerical post. So I did not join. And then, my lord, they themselves have admitted in their my lord case that though I was working for some days in the admissive section, but actually I was working from the beginning till today in the marketing section.
Okay.
In that affidavit they did not done. I have filed the affidavit here.
Okay, very well. Thank you. Yes.
Please, your lordship. Lordship, I have also, I have a constraint today. Lordship, I'll make it short, but
yes,
I have also filed a written submission, lordship.
Okay.
It was not numbered on the day when I had gone to check the pagination.
Okay.
I hope it is numbered now from 213 onward, lordship.
Okay. What is your brief submission? Just submit.
Submission. In that case,
You just briefly
yes, lot of what has happened is,
encapsulate.
this entire case has arisen out of a wrong understanding of the letter of appointment under letter dated circular 26/3/99 and 26/3/2000. Lordship, what has happened in that case? That letter was initially wrongly typed, and I think that perception remained. When it was corrected also, it just speaks, I'll just briefly, there used to be at that point of time, the entire was under General Insurance Corporation of India. There used to be two types of developments at grade 2. One who was on
In the
probation,
field,
others
one
who have
administrative.
completed probation and waiting in queue for promotion to grade 1. So there used to be annual letters every year, giving the targets.
Business.
One target was meant for on probation, like in this case, and that letter makes it very clear, Lordship. And the other group that the circular is talking about for promotion to grade 1. Obviously, they cannot be the same target, because that even that year is also specified, Lordship. In that year, the target for probation, completing a probation was 7.5 lakhs.
Hmm.
But for the say, in the same year, for promotion to grade 1 was this. Next year, the target shall save. And Lord said, this targets, this service of the petitioner lordship was under a government scheme, central government scheme, which was, the central government was required to lay before each house of the parliament, because it was as per General National Insurance Business Nationalization Act, Lordship. So Lordship, I have, in order to understand the schemes better, Lordship, two judgments of Supreme Court has analyzed these schemes and several cases. One of the judgments is this, Lordship, that says these schemes have to be laid before each house of the parliament, central government. After that, Lordship, so it's not given to anybody to change the terms and conditions of the schemes, Lordship.
Right.
As per scheme, Lordship, it's a very clear. Lordship, I'll take your Lordship to the correct page 127, 128. That later, Lordship. That will make it very clear, Lordship.
127.
127, Lordship.
Yes.
That corrected letter. And Lordship, in his appointment letter, I think I Lordship take your Lordship the appointment page 59, Lordship. Just in his page 59. That will make it very clear. His appointment letter gives him only one target, 7.5 lakhs. And his appointment is also governed by condition number 8 of the appointment letter. That says he'll will be given targets from time to time. Time to time, he has to year, Lord.
Yes, yes.
Condition number 8 is this. This appointment is and shall be subject to rules and regulations as may be enforced from time to time. He will also be governed by such instructions, orders as may be issued to you orally or in writing. Plus, every such instruction has to confirm the scheme, not
scheme.
Other because there's once this case also relates to some transfer issues of the and that is the Supreme Court. So the Supreme Court has always held the scheme to be, but then suggested that please don't transfer them unless it's in public interest. Otherwise, they have to be within cost norms. If they transfer, their cost norms will change. So, Lordship, this entire case, Lordship, I have written in my written submission. Yet only basically one grievance, two grievances that target for grade 1 should apply to him even during probation. Well, that is not correct, Lordship. And learned Singletons has Lordship taken care of all this in para number 8, 9, 10, and 11 of the judgment.
Okay.
All these points have been very clear, well taken care of.
Okay.
There's some other judgments also to understand the, I know, this would be sufficient, Lordship.
Very well. Okay, very well.
Lordship, just 1 year. I had my submitted written argument with initial page numbers. Then I give this for that.
No, we have located your written submissions. Give it all right.
No, this will.
Pass it on.
I have referred to these page numbers in my submission.
Yes, all right.
That will help it better.
Very well. Yes,
because the written argument contains earlier page numbers.
Yes, yes. All right. Arguments are judgment reserved.
Yes. Under
the one sentence I have left. One sentence only. My lord, they have mentioned that in paragraph in their affidavit that the subject to rules and regulations. I have brought the rules. Nowhere in these rules they have mentioned that this promotion of the. I have brought this. This is the rule. No rule was framed to my lord that they can change the target.
Very well.
This is the rule, my lord. Your lordship may kindly see.
You pass on a photocopy.
My lord.
Pass on a photocopy of the rule.
Yes,
okay, thank you.
The development officer grade 1 who has reached the maximum of the scale of pay may be granted for every 3 completed years of service stagnation increment. No increment was given. They kept me stagnant. And rule rather a development officer grade 2 not more than 3 such increments shall be granted. No increment is also given. At least minimum 3 increments. I am kept in a stagnant position. This is the rule. But rule does not say that they can alter the appointment letter,
you
alter
pass
the
on.
condition.
Pass on copy of the rules.
My
Yes,
lord, I will give the photocopy.
Yes. Next. Welcome. Yes.
Item number 8.
May I please, Lordship? Lordship has already heard the matter, Lordship, regarding our contention that the private hospital is a defaulter, Lordship. The same has already been confirmed by the government, Lordship.
It has been confirmed.
Yes, Lordship. Earlier also Lordship has.
Who is there for the government? Yes.
The appellant himself is a defaulter. He himself is a defaulter.
That is not the case because that is not the case because
If you are making that allegation, then we have to see both sides of the coin.
Lordship, both the parties have participated in the tender process, and as per the tenders, the rules prescribed for bar to the defaulter, Lordship, and accordingly, the private respondent is a defaulter, Lordship, and during
You filed the affidavit, Mr. Counsel.
no,
No,
Lordship.
my lord. Last occasion, my lord, we have filed. My lord.
Lordship.
So you were to file the affidavit.
Lordship, with due regard to the counsel for the private respondent, the counsel for the private respondent has entered APS by filing caveat, Lordship. On 13/5/2022, Lordship, he has appeared, Lordship. Subsequently, on 16/12/22, also.
We'll give you one short opportunity to file the affidavit. The counsel for the respondent number 1 is granted one more opportunity to file affidavit. List on 29th. Yes. This bunch of matters, Mr.
9 to 14.
You were to file something.
We have filed the affidavit, my lord, along with the notes.
Okay.
Which led to the decision-making process, my lord.
We'll fix it in the next week probably then. The affidavit with the notes pertaining to the decision-making process has been filed by the state. Re-notify on 23rd.
Also registered to bring this on record.
The registry to bring the affidavit on record.
Obliged.
23rd is fine, Mr. Chaudhary? Okay.
Item number 19.
Yes. What is this about? The matter was called out, done present. List on 24th.